Recording has started.
Do you want to introduce the meeting, or shall I?
Please go ahead.
This is the Sunshine Ordinance Task Force Compliance and Amendments Committee meeting of the City and County of San Francisco. This is a regular meeting taking place in hearing room 408 at City Hall, Dr. 1 Carlton B. Goodland Place in San Francisco. The date is June 27 and the time is 4:34. The telephone call-in number is 415-655-0001. The meeting ID 25910018-896##. Press *3 to enter the speaker line. Chair LaHood, would you like to do?
Sure. I'll read meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to the disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave.
Okay.
Please call the first item.
Item number 1, call to order, roll call, and agenda changes. Let's begin with roll call. Member Wolf.
Here, present.
Member Wolf, present. Member Wong.
Present.
Member Wong, present. Chair LaHood.
Present.
Chair LaHood, present. We have a quorum. I am not aware of any agenda changes. What about the three of you?
I'm not aware of any agenda changes. Members, do you have anything that you know about?
Only the one question from Ms. Schulman. Was that resolved?
Yes, unfortunately, we are going with the agenda as it stands because this is the agenda that was sent out.
Okay. Thank you.
Member Wong, did you have any suggestions, changes, edits?
I think it's too late to, but I think one thing was we didn't actually approve the minutes from the February compliance and amendments meeting in the April compliance and amendments meeting. So they were supposed to be, I think, in today's agenda.
I think you might be right about that. When we get to approval of the minutes, perhaps we can take action on that then. Meaning not take action, but we will have to, I will recommend that we put it on the agenda for our next meeting. We cannot approve it this time because the updated minutes were not posted.
Yep, sounds good.
Okay, please call the next item.
Item number 2, approval of the April 25, 2023 Compliance and Amendments Committee meeting minutes. I have a copy of the minutes if anybody would like to provide suggested changes.
Members, do you have any suggested changes? And Member Wong, if you'd like to make your suggestion, if you have any suggestions regarding past minutes that need to be approved, we could discuss that now.
Sure, yeah. So I think we do need to probably do approvals of the February minutes in the next compliance and amendments meeting. There's also one correction on the April minutes. So for agenda item 4, the motion is actually incorrect. So the two sections, 6726 and 6727, I think got mixed up. So it should actually be finding a violation of section 67.26 for not keying each redaction by footnote.
No, I think I have it correct.
I know it says 67.26 for failing to keep withholding to a minimum. Actually, it should be 67.27 for not providing appropriate justification for withholding.
I'm writing this
Just to
down.
clarify, so 6726 is for failure to keep withholding to a minimum. Is that correct?
Yeah.
It is, but that wasn't the motion. The motion was to find a violation of 67.26 for not keying each redaction by footnote.
I see.
And then it should be 67.27 for not providing appropriate justification for withholding.
Thank you for that clarification. Ms. Leger, do you have that?
Yeah, I was just writing it down.
Okay. Any other updates, clarifications, or corrections? Okay. Hearing none, I will make a motion to approve the minutes with the suggested corrections. Do I have a second?
Second.
Okay. Let's open this up for public comment on the April minutes. Mr. Young, do we have anyone wishing to make public comment on the minutes and suggested changes?
Yes, I do. Just for the other parties, if you would like to make public comment on this matter, if you're on the telephone, you can press *3 to raise your hand. Otherwise, you can use the application to raise your hand. I will unmute our caller. Caller has been
Hear me
unmuted.
now?
Is that Mr. Pilpel?
It is. Can you hear me okay? Sort of.
Yeah, I can. Just a moment, please.
We can't hear you, but it's a little blurry.
Okay, I'm on the computer and not on the phone right now.
Well, we can hear you okay for public comment.
Okay. So on the minutes,
Oh,
yes.
hold on one moment, please. Ms. Leger is going to start the timer.
Yeah. Maybe if you didn't speak so closely to your computer, we could hear you better. Because it is muffled sounding.
I could move to Daly City. How about that? Never mind.
That's better.
All right.
All right, you ready?
Sure. Okay. So David Pilpel, so on the minutes, yes, I agree that the February minutes are coming soon at the next meeting, perhaps. On page 1 of the minutes, near the top, regular meeting date and time, members, that's all good. I'm thinking listing the location, like City Hall Room 408, would be good on the minutes. I don't know why they're not on here. I was also a bit confused as I was reading through this. Member Wolf, I believe, joined late and left a few minutes early. That's fine. It was just confusing because he's listed as voting on item 2, and then there's a notation that he was noted present. Perhaps the notation should be prior to a vote, and then he was listed as being absent on item 8. So I can't remember if that was taken out of order. Anyway, I don't think Member Wolf did anything untoward. I was just trying to figure out what the sequence was, and it was a little confusing. So perhaps if someone can go back and just clarify those points, that would be fine. Also, finally, on item 2, I think the action reads a little weird. Moved by Chair LaHood, seconded by Member Wong, that the matter is continued until the next Compliance and Amendments Committee as amended. I don't know. Somehow I think that could be reworded. Moved and seconded that the minutes be continued until the next or a future Compliance and Amendments Committee meeting, something like that. Other than that, I didn't see anything huge and concerning. Those were my comments on the minutes. For tonight, I was really only interested in item 10, so I think I will probably disappear for an hour and a half or 2 hours and come back when you get to item 10. Thanks very much for listening.
Do we have anyone else wishing to make public comment on the minutes?
I do not see any other hands raised at this time.
Okay. Ms. Leger, I would accept a couple of the things Mr. Pilpel mentioned, maybe figuring out when Member Wolf returned in that vote, if it was entirely before 2 or somewhere in the middle there, but to make sure we acknowledge his presence before he appears as voting. And then sure, let's add the address at the top of the minutes and the location of the meeting. And for the action saying that approval of the minutes is continued until the next Compliance and Amendments Committee meeting. Member Wolf, do you accept those changes?
Yes, I do.
Just a moment, I'll be right with you.
I believe we're ready for a vote as on the motion as amended.
Yes, we were just waiting for Ms. Leger to finish her
Yeah,
notes.
Victor, they were just waiting for me to write everything down. Chair LaHood.
Aye.
Chair LaHood, aye. Member Wolf.
Aye.
Member Wolf, aye. Member Wong. Member Wong, aye. Moved by Chair LaHood, seconded by Member Wolf to accept the meeting minutes as amended by Mr. Pelpel and look to acknowledge Mr. Wolf's presence and the action approval of the continuance at the next Compliance and Amendments Committee meeting.
Do I get to use the gavel?
Yeah, you want.
Okay. I would like to make an additional motion to add approval of the February 21, 2023 Compliance and Amendments Committee meeting minutes with the amendments suggested at the April meeting to be added to the agenda for our next Compliance and Amendments Committee meeting.
This is Victor.
Mhm.
I don't believe we need a motion for that. The chair can just direct that to happen.
Okay, Ms. Leger, could we please make sure that we have approval of the amended February meeting minutes added to the agenda for our next Compliance and Amendments Committee meeting?
Okay.
Great. Thank you.
Okay, so this is June, so that would be August,
Mhm.
correct?
Yes. And then when you're ready, please call the next item.
Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Mr. Young, do we have any members of the public wishing to make public comment who are online or on the phone? And do we have anyone in the room who would like to make public comment? If you're interested in making public comment, please step up to the podium.
Yes, if you're online, either via telephone or via the application. If you're on the telephone, you can press *3 to raise your hand, or otherwise use the application to raise your hand if you'd like to make public comment at this time. I will give everyone a few moments. I do not see any hands raised at this time.
Okay, and we don't have anyone in the room who has stepped up to make public comment, so we will move on to the next item. Ms. Leger, please call item number 4.
Item number 4, file number 22014, complaint filed by Sergei Zverinov against Lieutenant Lynn Riley and the Police Department for allegedly violating Administrative Code Section 6721B by failing to respond to a public records request in a timely and or complete manner. On December 7, 2022, the task force moved to refer the matter to the Compliance and Amendments Committee for future monitoring.
Okay, Mr. Young, do we have the petitioner and respondent with us on the phone or online?
Okay, I have unmuted the petitioner. If the respondent is present, it would be appreciated if you can raise your hand.
This is Lieutenant Toomey for the San Francisco Police Department.
It sounds like we have both parties present.
Okay.
Mr. Severinov, I did unmute your line. If you can just go ahead and announce yourself so we know you're there.
Yes, I'm here.
Okay.
Thank you very much.
I'd like to start with Mr. Zverinov. Thank you for being here today. I'd like to give you a few minutes to give us an update on what additional records you have received since our last meeting, and if you could tell us if there's anything that you have not received that you believe should be sent to you.
First of all, I have a question. In the
Yes.
announcement of this meeting,
Mhm.
the text reads that this is a hearing on files 22020 and file 22014. Yet Ms. Leger only announced file 22014. So just to make sure that the committee is now today hearing both files.
Yes, we will be hearing both files, but just to make sure that we're keeping your requests, that we don't mix anything up, we're going to be hearing 22014 first. And then actually your 22020 is the next item on the agenda, so we will be handling that one second. I understand that it might be difficult to, that maybe some of the things you say may apply to both, but as much as possible, we would like to help you by focusing on the items you requested in 22014 first during this part of the discussion.
Okay, well,
Are we timing?
So, and because we've handled this before, I would just ask, I'm not going to set the timer with you, but if you could be as concise as possible, because so that we can spend time helping, giving you the help that you need.
okay, so the full Sunshine Ordinance Task Force heard both cases, or discussed both cases, let's put it this way, on June 7th. Prior to that, it was heard in December 2022. After the June 7th hearing, I didn't receive any documents, any disclosures, I would say, any responsive records from the police department. After the hearing on December 7th, I received a letter from the signed by Lieutenant Riley, to which I responded that Lieutenant Riley is no longer with the police department. Okay. So it was signed by a ghost name. The letter stated that the police department has exhausted their responses. And in the next sentence, they contradicted themselves. And they said that your request for body-worn camera footage has been forwarded to the body-worn camera unit for processing. Expect to receive a separate response from the body-worn camera unit, which I didn't. Okay, I didn't receive any response. The other thing that that letter said, letter dated December 19, 2022, and that referenced their file P062-599-021522. The other thing that it said that I'll just quote it. Certain emails have been withheld under the attorney-client privilege, which I submit to you is unlawful. If they did withheld anything, they should have provided a description, identifiable description of that could be used to identify those emails and make a judgment whether these are in fact protected by the attorney-client privilege or not. So there's just a blanket statement that certain emails have been withheld under the attorney-client privilege, whereas the Sunshine Ordinance requires them to provide a detailed description without providing content, but a detailed description that would be sufficient to identify those emails and make a judgment whether they are indeed protected and exempt or not. Furthermore, as follows from this letter that I received, the police department refuses to make a search of its email databases. No emails have been disclosed. No statement as to the fact that they searched for any databases have been made. And there are emails that I submitted previously to the Sunshine Ordinance that I have obtained from other sources. In particular, I have obtained them from the Department of Police Accountability that contain the correspondence between the San Francisco Police Department and Department of Police Accountability that reference my name and reference the name of my children. And these emails have been disclosed to me by Department of Police Accountability, but they were not disclosed to me by their police department. Why am I saying all this? To make the point that police department is refusing, and continues to refuse to make a search of their emails and either databases. Then finally, in the last hearing by the full task force 3 weeks ago on the 7th of June, there was a decision taken that the police department provide a sort of list of all disclosed documents. All the documents exist and have not been disclosed. According to the Sunshine Ordinance of San Francisco, they have to produce such list. And since last hearing on June 7th, I have not received any correspondence from the police department. That's it.
Okay. Thank you for that update. That was very helpful. Lieutenant Toomey, regarding 22014, can you explain why Mr. Zvernov has not received further documents or further correspondence or any indication regarding, or any further information regarding this request, and why there's been no response to our order of determination that was issued in October?
The San Francisco Police Department provided the respondent on June 9th with a link for the body-worn camera footage that he requested in this request. So he was provided that on June 9th, 2 days after the June 7th meeting that we had.
Okay.
And if I'm not mistaken, during file 20, the file that we're speaking of now, 22014, at our last meeting regarding that one, the request was focused on making sure that we got him the body-worn camera footage for that, and we did. I can remember we were having that meeting, and I made that request as we were speaking.
Yes.
And 2 days later, that request was furnished to him by our body-worn camera unit.
Okay, I remember that distinctly. And so, Mr. Zvernov, did you receive the email with the link, and were you able to view the footage?
No, I didn't receive it, and I certainly didn't view the footage.
Huh. Can I ask between the two of you, Lieutenant Toomey, which email address did you use to send it to? And let's have Mr. Zvernov verify that that is an active email address that he's using.
Working on that as we speak. Bear with me one moment.
Okay, that would be very important.
Correct. Give me 1 second to see if I can file through to get to that.
And Mr. Svernoff, do you have access to your, I don't know where you are. Do you have access to your email now where you would be able
Yes.
to look? Okay.
Yes, I do. And the point of all this is that the emphasis I made in the hearing on June 7th was that I caught the police department in the act of non-disclosure because the DPA, Department of Police Accountability, published a reference to particular video worn camera footages. Now, the thing is, I'm sick and tired of playing catch me if you can game with the police department. I have to dig out through other sources and mention a reference to a particular record existence, and then the police department will go and, as Lieutenant Tony said, okay, now we're gonna provide you because you caught us. The point of this, for a year and 4 months, they've been concealing it. They've been concealing it intentionally. And one of the things that I actually want to make sure you understand, they haven't done any search. They're just waiting for me to identify a record, and they will grudgingly release it. But they're not doing the search. That's the key to this. And what Lieutenant Tommy is saying, okay, that I identified 2 records, and they found them after I identified them. So now I will have to search for general references or open reference for other records. This is not how the Sunshine Ordinance is supposed to work.
Yes, I hear the frustration, from you that we've heard in this meeting and previous meetings. Lieutenant Toomey, have you been able to locate that email so you can verify exactly when it was sent on June 9th and to which email address?
Not yet. Sorry. I'm still trying to search through the myriad of requests. I don't want to. We have a number of different email addresses here. I want to confirm which one it was sent to.
Okay. While you're doing that, I'd like to offer to the committee members.
I apologize. I do have the email in front of me.
Okay.
It was sent to S as in Sam, E as
Actually,
in
before
Edward.
you say that, hold on. Before you say
I
it,
apologize.
Mr. Svernoff, is it okay if he reads it into the record, or would you prefer that?
That's fine.
Okay. Thank you.
Thank you. Sorry about that. I appreciate that. The email that it was sent to is S as in Sam, E as in Edward, R as in Robert, O as in Ocean, L as in Lincoln, G as in George, A, I have oh my goodness, I probably need a better set of glasses. A as in Adam at yahoo.com.
And can you tell us what time of day that was sent on the 9th?
It was sent on June 9th, 2023 at 11:56 and 14 seconds a.m.
Well, it would be actually makes sense to say who sent this,
Yes. What is the from email address that Mr. Sternoff?
Certainly, it was sent through our public portal. The sender was Lieutenant Christopher, Christopher Beauchamp, spelled Beauchamp. He is the lieutenant in charge of the body-worn camera unit.
Mr. Svernoff, are you seeing that either in your inbox or?
Well, I don't see that in my mailbox on June 9th, and I would request that the police department resend it. And again, this is something that's we're playing this catch me if you can game.
Yeah.
I believe that this is the something that really I brought up in a very convincing way by reference to DPA documents. Now, All right. So
Before you continue, can I ask, could you check your junk mail or your spam filter? And the only reason I say is I wonder if, because it was an email address you hadn't received anything from before, if it may have gotten, just to make sure that we've checked all corners. And in addition, I'd ask Lieutenant Toomey, since Mr. Svernoff is looking at his email right now, could you forward that email to that same email address right now, and we'll see if he receives it?
I don't know if I have access to actually forward body-worn camera footage based on my position. I have the ability to see what was done, but I don't believe I have the means of actually re-forwarding these emails with the links to them.
Okay. Well, while Mr. Svernoff is checking to make sure that it's not in a junk folder or a spam filter, I'd like to, fellow committee members, do you have questions for our participants here, and how can, what questions do you have?
Member Wolf.
Member Wolf, please.
Yeah, so I think what would really be helpful is I understand that Mr. Svernoff would like for the police department to do a more extensive search. The problem is that without us knowing or having some idea from him what he's looking for exactly, it's hard to just have an open-ended kind of search. If there's something that he knows that is missing, or that it's like not like he has an email message at one point, an email message at another point, and they obviously something was happening in between, and those messages are not there, then we could zero in on exactly a period of time. It's a little difficult to just say, respondent, go and do a more extensive search and see if you can find something. That's not something that we generally do. So if Mr. Svernoff, if there's a specific document that you're hoping to find, or that you're interested in having disclosed, then that would be really helpful in zeroing in exactly in what you're looking for, what your needs are.
Can I respond to this?
Sure.
Well, I mean, I think these words are putting the Sunshine Ordinance from the head upside down, because the section 6721C says that the respondent, in this case police department, has a positive duty to identify the records and provide a list of the records, exempt or otherwise. The San Francisco Police Department is not an open and transparent organizations.
Yeah, but I understand that, Mr. Svernoff, but I understand what you're saying with regards to that section of the code. I understand what you're saying, but we can only go by what the respondent's testimony is. If they say they've done a full search and this is all they can find, we can't, unless you can identify that there's something specific that is missing, we have no way of sending them back to do things that they may not find. That's not our job. It's not our job.
Section 6721C obliges them to provide a full list of responsive records with detailed description, easily identifiable, whether exempt or not. They have not done it. They have not fulfilled their obligations under 6721C. And if you listened to me earlier, you would probably have heard to me that the San Francisco Police Department said they haven't done search of either emails. Second, they said certain emails have been withheld under the attorney-client privilege. So they have the records. They know that they have them. but they haven't provided a list of them, easily identifiable and with details. What are the emails? And that is something that they must do, provide a list, identifiable, detailed list without the content, but the list such that it would be possible to challenge and possible to make a judgment whether they are in fact exempt or not.
Okay.
The statement certain
Okay.
emails have been withheld is not sufficient.
In the interest of time, okay. Lieutenant Toomey, have you provided such a list of communications or documents or records or what have you, in the way Mr. Smirnov is explaining?
He requested, and we actually did a keyword search of the names that he gave, and we provided him 607 pages, of email documents that contained the keyword search of the names that he provided. We did, in that correspondence, advise him that there were emails between members of the San Francisco Police Department and members of the San Francisco City Attorney's Office that were attorney-client privilege emails regarding how to conduct and what we needed to do in the way of search for this Sunshine Ordinance request. So we have done a full search of every email that we possibly still have in our possession and provided him 607 pages of those emails.
So, Mr. Smirnov, I understand that you found other emails that you received from the Department of Police Accountability. Is that correct? That were not, are you saying that those were not in the pages provided by the police department?
That's correct. And again, the statement by the police department as verbatim, the statement from the letter, certain emails have been withheld under the attorney-client privileges, is a mockery of the law. If they have those emails, they have to provide a detailed description, numbered description with details of those emails, how many, identifying each separately, so that these emails can be, their content or privileges can be challenged or not.
So, Lieutenant Toomey, is there a reason why Mr. Smirnov has not received a listing of how many emails were withheld for attorney-client privilege, or if that has already been provided, forgive me for not seeing that, but can you offer some more details on that?
No, other than whenever the issue is, we would provide the city attorney with the full file that was presented, just like it was presented to you folks. Mm-hmm. And we would, as an attachment to an email stating how far, we would ask certain we'd be asking for certain legal advice from the city attorney's office. And right. So those emails have his name attached to them because they contain that long myriad of information. And then there is a back and forth communication between ourselves and the city attorney's office. Do we have a comprehensive list of those emails? No, we have just told them that discussions and emails that we have between ourselves and the city attorney regarding this matter, we have emails, we are not disclosing them due to attorney-client privilege.
Okay, one other question. Hold on, Mr. Smirnov, wait, Mr. Smirnov. Lieutenant Toomey, can you explain why Mr. Smirnov may have received emails from the Department of Police Accountability that involved correspondence with the police department that were not part of the release sent directly to him?
There could be a myriad of reasons. Mainly, we're no longer in possession of the email. It could have been whomever within the police department was contacting the Department of Police Accountability could have easily just erased it, and we are thus no longer in possession of it. I question or wonder exactly what that correspondence is based on the fact that the Department of Police Accountability is an outside entity that we don't necessarily, we communicate with, but they are not a part of the police department. We don't have the ability to search their email archives. we don't have the ability. We weren't asked to contact the Department of Police Accountability and ask for all of their records that they have regarding the complainant.
Okay.
So my main reason would be that when we did the keyword search of the individual and those names that he provided, that is what we still have in our possession. What might have been thrown out because it was thrown out because it's no longer a working document, it's gone.
And you may have answered this question in a previous meeting, but just to make sure we're all on the same page with this, can you tell us what the department's policy is regarding deleting emails?
We don't have a retention policy. Once the document is no longer needed, it can be erased by whichever member it is in their inbox.
Okay, and so that is a department policy, and that would explain why certain emails that may still have been retained by the Department of Police Accountability and yet not retained by the individuals who sent them within the police department.
Correct, and it's encouraged by our IT unit to regularly clean out our inbox so as to not have a large inbox that would bog down our system with digital storage.
Okay, thank you. And Mr. Svernoff, were you able to locate the email with the body-worn camera video in either a spam or junk folder?
No, I haven't.
Okay. Okay. How are we going to remedy this, Lieutenant Toomey? How are we going to make, because if the email was sent, but Mr. Svernoff is not receiving it, I feel like we're going to continue going around in circles. How are we going to make sure that this information is sent to him and confirm that he has received it?
I really don't know, other than I can have the request sent. I can have the officer in charge of it send it again. I can confirm, based on the audit that we have here, I can see that the document was not viewed by the complainant. I can see that he has reviewed other documents that have been put into the portal before. I can see that he is. I'm trying to review through here. We can kind of look to see. It does not appear, though, that he has viewed it. So
Okay.
I can send it again. I can request to have it be sent again. It can be sent again in the morning tomorrow. But I can't force them to open it once we send it.
Okay, here's what I would like to request, that you have it sent to him in the morning again tomorrow. And I would
Certainly.
also like to request that it be CC'd to Ms. Leger, our administrator, at sotf@sfgov.org. And she can verify that if she receives it, and then maybe we can also check in, we can confirm that it was sent. We can check in with Mr. Svernoff and make sure that he has received it and is able to view the footage.
I have an objection to that, because
You-
the
oh.
records requested are requested to be viewed by myself and not anybody else.
If it's going
It's
to
a
be
public
released,
record.
It's a public record. It's a public record.
Well, it's a public record that's being released to me. Ms. Leger didn't make a request. If she makes a request for that,
No.
So all
I've
public,
actually I have just received a public records request from the Sunshine Ordinance Task Force to provide that document.
so
Have I not?
Let's
Yes.
wait a minute. Before we go down that road, okay?
Thank you.
Okay, before we do that, okay? I appreciate what you're saying, but that's jumping the gun a bit, okay?
Okay.
I would just say, first of all, any record that's being requested that the Sunshine Ordinance Task Force is deemed a public record, which allows us to then have this hearing, is a publicly accessible record. Mr. Svernoff, if you decided that you don't want that record to be exposed, then that you should have thought about that before. I mean, it is a public record no matter what.
I haven't seen that record.
It doesn't matter if you saw it or not. It's still a public record. That's what we're trying to for them to release. But if we request a copy of it to assure its delivery, then, it's allowed.
I don't think Sunshine Ordinance allows you to request a record of that's being released to me.
Absolutely.
Yes, it does.
Absolutely, sir. Absolutely, sir. The Sunshine Task Force can order documents to be released.
Well,
Absolutely.
then this order should be made, and public and I should be able to contest it.
Well, it doesn't matter, because if we found it to be public, anybody can request it. Anybody.
Sure. Well, you should make a request then.
We don't need to. We've already made the order for it to be disclosed. They already said that they've tried to send it to you. Okay, it's already a public record. Now we're just trying to assure that it does get delivered to you. All we're asking is that they CC us so that when we receive it, we know that it's been sent to you.
And
Well,
Mr. Fairnough,
It's just confirmation.
I want to assure you that Ms. Leger has no interest in actually viewing this. The whole reason in asking her to be CC'd on this is to ensure that the document is sent to you. Otherwise, it would be a shame to have to wait another 2 months to find out that you still haven't received it because of some technical issue. And so I want to make sure that this is going through, and this is the best way that I can think of to make sure that you're going to receive this in as soon as possible, which seems to be tomorrow morning.
Well, my objection stands. There is on some of those videos that they send, there is police department molesting my minor daughter. This is something that's of great sort of stress and of great emotional suffering for us, and therefore my objection stands.
Madam Chair, through the chair, then this should have been taken up in court.
Yes.
Because in court, they can hold things in camera. And if that level is of objection that you have, then you could make a motion that a video not be released and that it only be seen in camera by the judge and the judge only. That's not
My objection stands. That's it.
That's not us. Okay.
I'd like to ask committee members, the only reason for me to make that request is to ensure that Mr. Smirnov is receiving the footage, which thus far he says he has not. I have no problem with asking Lieutenant Toomey not to CC us on this, but then we're going to, I think, run into a situation where we're going to have to come back in 2 months and go through this again. But I'm fine with withdrawing that request because I do not want to cause Mr. Zvernov undue distress, even though, we're discussing this and someone else could request it. But I don't want to cause him that distress unnecessarily. Do you have thoughts on this?
Madam Chair, let me just ask. I just want to ask Lieutenant Toomey a quick question. Was this record, that's a video, was that provided to Mr. Zvernov through your portal system?
Yes, it was.
Okay. Mr. Zvernov, did you access the portal system to find that? Never mind email. Have you logged into the portal system to be able to find that document or that record?
So I haven't. If you are speaking about something that has been allegedly sent to me since the hearing on June 7th, then the answer is no. Since June 7th, I have not received any new disclosure, any new emails.
You logged? That wasn't my question. Did you log into the police portal system?
In the past, yes. In the past, yes.
No,
not
I mean,
since June 7th.
Why not?
In the past, yes. Not since June 7th.
Why not?
Because
because your record is protected.
Okay. What happens is that I receive an email saying these are the records for you. Now, when I click on attachments, well, they probably are hosted on the police records. Okay. So I click on and go to retrieve documents when I receive a notification of them. Since June 7th, I have not received any notifications.
I have nothing further, Madam Chair. I don't know
if
how
I may,
I don't know how to dispense with this at this point because I don't
If
really know what records are still outstanding, except for this video and one email.
Lieutenant Toomey, yes, please go ahead.
yeah. So thankfully, excuse me, the body worn camera unit CC'd me on the June 9th email to the complainant. I'm looking at that. I could forward that email to the Sunshine Ordinance Task Force email right now.
No, forward it to Mr. Zvernoff right now, please.
Oh, that's even better.
That's what I would like you to do. And Mr. Zvernoff, yes.
SEROLGA@yahoo.com.
Is that correct?
Yes, it's correct.
Okay.
And also there are, as I mentioned in the letter of December, about a number of emails that have been withheld due to claimed client attorney privilege without a list of those emails. It's not one, it's many.
Okay, I'm focused on the camera footage first. Lieutenant Toomey, let us know when you've sent it.
It
And
has
Mr.
been sent.
Zvernoff, okay, Mr. Zvernoff, if you could just watch your inbox right now, I would like to confirm that you have received this email.
I'm watching it.
Okay. Thank you, everyone, for your patience. It's if we can resolve any pieces of this on the spot, all the better.
Yeah, I have received it.
Okay.
Yeah, I've received that email. Yes, I received it.
Okay. Are you able to? I don't need you to watch everything, but are you able to click on the link and access where the footage is located?
I will click on it as soon as I have time. Right now, I'm focused on this meeting, and I don't think I can.
Okay, that is fine. But you are satisfied that you are satisfied that you have received the link to that information, and I am hoping very much that you're able to access it without any problems at this point or after the meeting.
What I see here is a list of two. So they're not attached to it. But I see here a list of two videos. A list of two videos of December 22nd, 2021. The ones that I mentioned in my address to the full task force on September 22nd. And again, I want to say that the police department really forces me here to play catch me if you can game. Once I find through snoozing or other means that there is a certain records, then they reluctantly release it. There is a list of emails from that are responsive to my request that they claim privilege and exemption. Well, they, according to the Section 6721C, they have to provide a detailed list with detailed descriptions of those emails.
Okay. Mr. Zvernoff, hold on one second. I'd like to discuss with my fellow task force members. Task force members, do you have any additional thoughts regarding the emails between the department and the city attorney's office being withheld for attorney-client privilege? This is something that we encounter all the time. I don't think we've ever had success getting past that. But are there any cases where you can recall that that departments provided a list or an enumeration of emails or other records that were being withheld because of due to attorney-client privilege that were about communications with the city attorney's office?
Well, the letter I received
Hold on, I'm
doesn't
talking,
say.
I'm not
No,
talking, Mr.
no.
Sarnoff, I'm really sorry. I'm talking to Member Wong and Member Wolf right now.
This is
Okay.
Member Wong. I'm not aware of any cases where we've been able to acquire records that have been protected by specifically that privilege.
And my only experience is that it's up to the client. The attorney-client privilege it's only for the attorney. The client has the ability to release them or not. If they choose not to release them, then that's their prerogative. But the attorney is under attorney-client privilege, cannot release them. Now, I also want to say that there's nothing in 6721C that discusses a list of anything. It just states that a statement of the existence, the quantity, the form, the nature of records. Okay. Now, you want to call that a list? Okay, fine. It's a list, but it's really just a statement that that these records they exist. They don't have to be produced. They just have to be notify that they exist, so that a requester can make a request of whatever is available. Now, that is the purpose of the index of records. That's what that's there for. So if the police department has a robust index of records, which should be publicly available on the city's website, that should also provide an additional place for members of the public to go to. That's all I have. Yeah, attorney-client privilege. If it was an attorney that was here, they would say absolutely not. I cannot release that unless the client wants to release it themselves.
Okay. Thank you, members. This reinforces my recollection of our past experience, and I appreciate you helping with those details. Just as a matter of course, I'll ask Lieutenant Toomey, would the police department consider waiving its attorney-client privilege on any of those emails?
No, we would not.
Okay. Mr. Svernoff, I believe this is as far as we can go with this particular case. I'm glad that we were able to ensure that you have access to the body-worn camera footage. But at this point, I don't think there's any more to be done regarding complaint 22014. Now, that said, if we resolve, if we decide to close this matter today, if you become aware of any new or additional information and want us to reopen the matter, you can come back. But at this point, members, I think we've gone as far as we can regarding compliance with this case. Would you agree?
The letter that I received from the police
I'm talking to the members, please. Members, do you have any additional thoughts?
No, I concur. I concur with that.
Okay, Mr. Svernoff, I know you were trying to say something else, and I'll give you a chance to say what you were trying to say. Please go.
The letter that I received from the police department on December 22nd of 2022 does not claim that these are letters or correspondence between the police department and city's attorney's office. That's something Mr. Toomey has just added into this conversation. I do not want to take this word as a last letter in this. The specific written response said there are emails that are, in their opinion, covered by attorney-client privilege. They don't say that these are emails between San Francisco Police Department and the city attorneys. So an index has not been provided. Okay, so this is something that needs to be provided, whether they are indeed between the city attorneys and police department or not. just taking this on faith.
Mr. Zvernoff, I'm really sorry. I'm going to stop you now because we have more items on the agenda, including another item for that that is one of your cases. The city attorney is the city attorney provides counsel to all city departments. If the police department is claiming attorney-client privilege, it is with the city attorney. That is their attorney. Their attorney is the city attorney, unless they explain otherwise. That's not something that they would. I mean, I think it helps members of the public to explain that, but we understand implicitly that the city attorney is providing the counsel that is covered by attorney-client privilege. And as Member Wolf explained, they are not required to provide an index of those records, which they are withholding because of attorney-client privilege.
I think he said they are required to provide an index.
No, Member Wolf, I think you were referring to the index of records, not an in. If you could explain to Mr. Zvernoff the distinction.
So the index of records is a category. It's based on category of the different kinds of records that are being curated by any and every department. Okay, and it makes it easy for, or it should make it easy for members of the public to be able to at least narrow down where or what they can be asking for their interest. That the attorney-client privilege is a completely different animal. Basically, those are documents that are between the client and the attorney. The attorney-client privilege is specifically for the attorney not to disclose any client information without the client's permission. If the client wants to release the information themselves, that's their business. But the attorney has an obligation under attorney-client privilege. Okay, the client can do whatever they want. So if the police department wants to release that information and they make that decision, even if it's against their attorney's counsel and advice, they can still do it. But if they say no and they don't want to release it, then they don't have to release it. We can't necessarily, we can only compel them so much. Okay, and that's why the Sunshine Ordinance allows for members of the public to use the judicial system if they are not getting satisfaction out of the ordinance. And it's written in the ordinance. Doesn't disallow anyone from going to court and trying to have a court try to get it released. We don't have that same authority.
I'm looking only for 6721C statement to the existence, quantity, form, and nature of records relating to a particular subject. That's all I'm asking for. And
yeah, I understand that. You're saying that you never received the statement of the records, that you were just a list, or as you say, right? You never received that list.
To the existence, quantity, form, and nature of records relating to a particular client, with enough specificity to enable a requester to identify records, and that is concerns not just public records but also exempt records.
Okay. Madam Chair, I think that narrows down exactly what Mr. Zvernoff is asking for. Okay, I'm not clear as to whether that was his original request. Because I'm not going back into the beginning of the annals of this case.
Forgive me, Member Wolf, but I believe he is referring specifically to the documents withheld for attorney-client privilege. Mr. Zvernoff, is that correct? You're asking for an index of the documents withheld for attorney-client privilege. Is that what you're asking for?
Any other that they have withheld for any other reasons?
Lieutenant Toomey, has the department withheld records for any other reasons than attorney-client privilege?
No.
Okay, so all of the records that have been withheld are covered by attorney-client privilege. The police department has not provided an index of those records, and the task force does not believe they are required to provide an index of the records withheld for attorney-client privilege. Members, are we in agreement on that? Or do either of you hold a different position about their duty to provide an index of records withheld for attorney-client privilege?
67.
That,
No, Mr. Zveranov,
no.
I'm asking Member Wolf and Member Wong.
Member Wong, if you, do you want to go first?
I mean, my understanding is that if it's requested, it's something that should be provided. I'm not sure if there's any specific stipulations around attorney-client privilege, though. So I'll let Member Wolf speak to that.
Yeah, so, I understand what Mr. Smirnoff's asking for in 6721C. He basically feels in his reading of it that the statement of disclosure or the statement of existence should include whether it's documents that are exempt from disclosure or not. Okay. I would have to confer with legal counsel based on the constitutional construction of this, because the statement doesn't necessarily say that it includes records, whether they're exempt from disclosure or not. It basically says it doesn't matter if there are records that are exempt or disclosure or not. That there should be some statement as to the existence of any records. So if there are records that are protected or that are being protected or not released, then that's a level of identification. Okay, I know that he wants to go through the whole list of it. He wants to know how many there are. The form and the nature of the records, okay? So if they're being held as confidential, okay, they can be withheld. Then the ordinance requires there to be a reason given for the reason why they're being withheld, and it needs to be cited by law. Those things are there. The thing here is again, if the original complaint did not cite 6721C for this particular purpose, then why are I'm a little concerned as to why we are discussing it here. And I'm asking that question again. Is that part of the original complaint? And is it part of the what we found as to be the violation?
Actually, Member Wolf, you just said something very insightful. If the request was filed on a particular date, and if these emails back and forth between the police department and the city attorney were about fulfilling the request, then they came into existence after the request was made.
Yeah. Well, so I'm just going back on, now I'm looking into the record. So order of determination, September 7th, 2022. Moved by Chair Yankee, second by myself, to find that the police department violated 6721 by failing to provide assistance in finding the records. Okay. Didn't necessarily specify about a list.
Oh, but there is a list. There is a list because the original public records request from February has a very clear, excuse me, their response was in February. There's a very clear list of what he requested. And it was in fact 25 line items regarding his specific requests. And it wasn't just about emails. It was, documents and any records regarding this list.
Okay. Fair enough. There you go.
Lieutenant Toomey, I'm going to come back to this because you said that there were emails that are covered by attorney-client privilege, and you had said that they were regarding fulfilling the response to this records request. Is that correct?
That's my understanding, yes.
That is your understanding. Were they, is it possible that they involved responding to other prior records requests?
Good question. I don't know if they are, because they were not my personal correspondence.
Mm-hmm.
I do not know if those correspondents were dealing with other public records requests. I do know that the correspondence with the city attorney regarding this subject specifically were detailing responses to public records requests and no other subject.
Okay. Mr. Svernoff, you're hearing what Lieutenant Toomey is saying about that. Is that clear to you, that the communications were specifically about responding to your records request and not other subjects?
Okay, let's look at what the letter said. The letter said there are responsive records that are exempt. Responsive records means that they are covered by the timeline of my request. So what you're trying to say is basically that they are not responsive records because they were created after my request. But that's not what their letter says. The letter says they are responsive records. And I want to tell you one more thing again. In my file number 22020, in your agenda specifically cites section 6721C. And I urge you to read that section 6721C that says that the custodian shall assist the request in identifying the existence, forms, and nature of any records, whether or not the contents of those records are exempt, and shall, when requested to do so, which I did, provide in writing within 7 days following receipt of the request, a statement to the existence, quantity, form, and nature of those records. What I want to tell you that it's been a year and a half. Compare this to 7 days, and you should all look at yourselves in shame, okay? We're talking about this after a year and a half, talking about whether they should be providing what 6721C requires or not. Okay? This is just completely shameful that a year and a half we're talking about something that they should have done in 7 days. And again, keep in mind, you're now trying by speculation, by all kinds of wishy-washy arguments, to say that these records are now not even in the time frame, when the police department itself said these are responsive records to your request, and we are exempting them. And now you want to add to this another argument and say,
"Oh, Mr. Svernoff, I am looking back at
shame
your."
on
Hold
you.
on. Okay,
shame
listen.
on you.
Actually,
Hold on. Listen, I'm not taking offense at this. I am proceeding methodically. I'm looking at the complaint again. And sorry, but go ahead, Member Wolf.
I just want to say that, I remember when the motion was made and what was discussed at that time, the section of this particular part of the ordinance was not part of what was necessarily discussed. What was more focused on was the very last sentence of 6721C, was about providing assistance. Okay, wasn't necessarily about the statement of existence. Okay, now you may want to say that I'm splitting hairs on it, but that's exactly what was of discussion there. It wasn't that there was a specificity of the statement of existence of, and there should be a production. And that's the way I recall it. Now, you're right. This has taken a very long time to get here. And what is helpful is if we can identify which records you are not receiving. And if you have specific records that you are not receiving, then it makes our job a whole lot easier to then say, okay, do they exist or don't they exist?
So member Wolf, if you go, so in the file on page 7 of the PDF, although it says, or 15 at the bottom, and Mr. Smirnoff details what he received on November 22nd, and there was reference to responsive records, but without disclosure. And then
yes, I see it.
And so you know, there are details here.
That's why I'm only asking what is still outstanding.
Right. Well, Lieutenant Toomey is telling us that what is outstanding at this point is communications with the city's attorney's office about how to respond to records requests from Mr. Smirnoff. And Mr. Smirnoff, you know, it made the point that if they told him that things were being withheld in their response, that, you know, these at least in their minds, these were part of their search, and you know, we'll take it at that. But what we're hearing from Lieutenant Toomey is that the reason these are being withheld is because they're covered by attorney-client privilege. I think Member Wong made an interesting point regarding, you know, maybe, you know, when requested to do so, provided in writing within 7 days following receipt of request, a statement to the existence, quantity, form, and nature of requests related to a particular subject or questions. And it doesn't, it says even whether or not the contents of those records are exempt from disclosure. We can make this, I mean, Madam
Chair, let me
Yes.
just want to, before you say that, I just wanted to say under 6721C, it's not asking for disclosure of those records.
No, it's
All
not
it's
asking for disclosure.
it's just asking for, do they exist?
Yep.
How many are there? And what is the form and nature of it? So in this state, it could be, yes, there are these records. There are like 5 of them or 10 of them or 50 of them, and they are confidential and they're not being disclosed based upon and citation, whatever, evidence code or whatever. Okay. And that's all that Mr. Smirnoff is asking for. Okay. Because the respondent had testified and had told him that there were documents being withheld under attorney-client privilege.
So, Lieutenant Toomey, at this point, we know what is being held. We know that it's emails being withheld. We know that the nature of them is that they're communications with the city attorney's office regarding responding to records requests from Mr. Smirnoff. Could you provide us a number of emails that are being withheld under this exemption?
If you bear with me one moment, I can try to see if I can get you the number of.
Okay, thank you.
Madam Chair, while we're waiting,
Yes.
I just need to notify you, I have a hard stop at 7 o'clock.
Oh, no. Okay.
Two
emails.
Yep.
Regarding the request. We're talking about file number 22014. 2 emails between the police department and the city attorney's office are being held under city attorney-client privilege, and the nature of the discussion of those is responding to public records requests.
That's correct.
Okay. Could we have you put this in writing in an email to Mr. Smirnoff?
Oh, I misspoke. It's 2 total emails, 1 to, 1 from. So I hope
Okay.
that I just wanted to make that clear.
Okay. Could we have you detail this in an email to Mr. Svernoff so that he has it for his record that the police department is withholding 2 responsive records, 1 a communication from the police department to the city attorney's office, 1 a communication from the city attorney's office to the police department. Both are emails, and they're being withheld under attorney-client privilege because the nature of the discussion is about responding to Mr. Svernoff's records request.
Sure.
Okay. Mr. Svernoff.
Yeah. Can
I
I
think-
speak?
Yes, I think this is as far as we get with this, but please.
Well,
Yes.
obviously, yes. But if given that what you're doing is you're providing advice and guidance to the police department how to respond. Shame on you. This is not your job to provide advice and guidance to the police departments. Yet
You want
took
us to,
their
Mr.
position
Mr.
Stern, you want us to
Mr.
compel.
and
Mr.
you're
Svernoff.
want us
just
to
complete
compel,
American
and
racist.
that's what we're
That's
doing.
who you are.
Okay.
You
Mr.
want us to
Svernoff?
compel and order them to do things? That's what we're doing.
That's what we're doing. And would you like to know why I asked him to put it in writing?
I know why,
asked-
because you're a racist.
I'm racist. Okay. Mr. Zernoff, I understand your frustration, and I'm not taking what you're saying personally because I know you're frustrated with the process. And we are trying to help.
Are you a
But I understand that
psychiatrist?
you're frustrated.
Are you a
What?
psychologist?
No, I'm
How can you detect my mental condition? It's not your qualification.
Okay, you're right. You know what? You're absolutely right. But my qualification is I'm trying to get documentation for you so that because it seems as though we have evidence that you are making many requests of the police department and other agencies. And what I'm trying to do is make sure that you have documentation of this. Obviously, this meeting is recorded, but I thought it would be helpful for you to have an email record that documents what we've just discussed. And that is why I asked the police department to document that for you.
You're
That is what I'm trying to
dictating and providing guidance as to how the police department should respond to
No,
my
I am Mr. Svernoff.
request.
I am
That's
trying.
a shameful
Mr.
racist
Svernoff.
behavior.
Okay, Mr. Svernoff, I am trying to help you. I'm just going to say it again. I'm trying to help you because you come to us asking for specific things, and I want to make sure that you are getting those specific things. That is what I am trying to provide. Because what I don't want to happen is for somebody to send you an email again and that you don't receive it. That's why I'm spending so much time with you working on this. And that's all I'm trying to do. Members, could we have, I think at this point we have agreement from Lieutenant Toomey to send that email. Perhaps we are not ready to close this because we want to make sure that that email gets sent. Lieutenant Toomey, since there's nothing sensitive in that, if you could please CC Ms. Leger at sotf@sfgov.org, and we can confirm that that email is sent to Mr. Zvernoff, that would be very helpful. Members, how would you like to proceed?
This is member one. I think once we have confirmation on receipt of that email, that it would make sense at this point to close the file.
Oh, if you give me about a minute, I can probably try to get this email out and you can close it right now.
Okay, let's do that.
I'm not a very good.
While Lieutenant Toomey is taking care of that, Member Wong, would you like to make a motion? And we can, if you'd like to start making a motion, and we can see where we go from there. We will be taking public comment on any motions.
Okay. I'm trying to recall exactly what we typically say and in terms of what.
Is Mr. Young on the line?
Yes, I am.
Yes, he is.
Mr. Young, I know you've provided guidance on this before. When we're closing a case, what is the appropriate language that we should use for that also allows reopening should additional information become available?
That last part I'm not too familiar with, but usually it would be to find that the department has complied with the order of determination and the matter be closed. In terms of reopening, we usually don't put in a provision for that.
Right, we don't put in a provision, but it's in our it's in our bylaws that there's a mechanism for that.
There's a mechanism that if new information comes up that has not yet been provided, that would change the action of the task force. We do have a provision for the petitioner to request that the matter be reopened. But it has to be new information.
Reconsideration, and it's
Yes.
done within 60 days.
Okay. So yeah, I think the formulation of the motion will likely be then just to say that the police department, San Francisco Police Department, has complied with the order of determination and that the matter be closed.
Okay. Ms. Leger, we received an email?
Oh, still typing. Hold on. The records are...
We can go ahead and open up public comment while we're waiting for that to come through.
I don't have access to my email on this computer.
I can check myself.
Okay, great. Thank you.
Actually,
to make a quick correction, in our it's in our complaint procedure under Article E1. It's actually 30 days for reconsideration.
Thank you.
Okay, while we're waiting for that, would you like to go through the public comment?
So we don't have a second on it yet, and I think the Member Wong, is the motion contingent on confirmation that this email has been sent?
Yeah, I would say so. I think that would indicate.
I need to give a file 22014 sent. It's sending.
Okay. Mr. Young, if you can just confirm.
I do see it. I have it. I have an email from Lieutenant William Toomey. Per the order of the Sunshine Orange Task Force Plan regarding file 22014. I do have an email.
If it's short enough, could you read it into the record?
Yes. I do have it CC to serolga@yahoo.com. Per the order of the Sunshine Ordinance Task Force Compliance and Amendments Committee regarding file 22014, the committee requested that I advise you that we are withholding 2 responsive records between the police department and the office of the city attorney regarding your public records request. The records are protected as attorney and client privilege and consists of email communication, 1 to the city attorney from the police department and 1 from the city attorney to the police department.
Okay, thank you. Member Wong, if you'd like to make your motion, I think that would be appropriate at this time.
Okay. Yes, I will make the motion as stated earlier.
Are you concluding and the matter is now closed?
To find that the department has complied with the order of determination and the matter be closed.
Matters.
And do we have a second?
Second.
Okay, I would like to open this up for public comment. Any members of the public wishing to make comment on this motion? If you're in the room, please step up to the podium. If you are online or on the phone, please signal to Member Young that you would like to make comment on this motion.
Yes, you can use the application, WebEx application, to raise your hand. Okay, I do not see any hands raised for this matter.
Okay, Ms. Leger, please call the vote.
Member Wong?
Aye.
Member Wong, aye. Member Wolf?
Aye.
Member Wolf, aye. Chair LaHood?
Aye.
Chair LaHood, aye. Moved by Member Wong, seconded by Member Wolf to find that the police department has complied with the order of determination and the matter is now closed.
Okay. Thank you. Please call the next item.
Item number 5, file number 22020, complaint filed by Sergei Zveranov against the police department for allegedly violating Administrative Code Section 6721 C as in cat by failing to respond to a public records request in a timely and/or complete manner. On June 7, 2023, the task force moved that there is a violation of Administrative Code Section 6721B for not responding in a timely manner or within 10 days, and to forward the matter to the Compliance and Amendments Committee and request that the police department provide copies of documents provided to Mr. Sparinov and list other categories of responsive documents that they may have under its jurisdiction, and to provide as a follow-up process in order that they turn over the body camera footage within 2 weeks.
Okay. It seems, looking at this, that because these two file cases were so close, I think some of our discussion has crisscrossed here because, well, actually, I'd like to hear from Mr. Svernoff first. And Mr. Svernoff, as with the previous file, I'd like to give you a chance to talk about anything specifically related to this complaint that has not yet been satisfied. I think we dealt with the body camera footage, unless this is different body camera footage that we're referring to in this case. Can you tell us, is there any material that was part of this request for 22020 that you have not yet received that, according to our order of determination from June 7th?
Well, the order of determination said that SFPD should provide copies of all documents provided to Mr. Severinov and list other categories of responsive documents that they may have under their jurisdiction, and to provide as a follow-up process. And none of that has been done. So basically nothing has been done except for the footage, which has been turned over in. Basically, if we're referring to the footage that was done to that been referred to today, it's 20 days since that hearing. So, but neither copies of all documents were provided, nor list of other categories of responsive documents have been provided. And I understand that SFPD has failed to comply with the motion and decision by full task force on September 7th.
Okay. Lieutenant Toomey.
Yep.
Can you explain to me why, can you tell me why Mr. Svernoff has not received a listing of the responsive records that he requested in file 22020?
It was my understanding during that, and it might have been through miscommunication, that the request in the listing was requested to be provided to the task force committee, and then would be addressed at the committee amongst both parties. So we responded on the 21st of June and provided the listing to the task force, not to the complainant. So maybe the motion, reading the motion, it was my understanding that you as a body were asking for the listing, not to produce that listing to the complainant.
I see. And Ms. Leger, what did you receive from Lieutenant Toomey?
If I had received something from him, I would have forwarded it to Mr. Svernoff. Let me check the last last Friday, as you know, I uploaded the agenda.
Yes.
And the last day to provide documentation would have been that Thursday before. So is that the 25th?
The Thursday before was the 22nd.
22nd, okay.
Everyone, thank you for your patience. Just give us a moment, please.
Documents with me, unfortunately.
Is this something that Victor would be able to see? Does he have visibility on that account?
If you can describe it to me, I can take a look.
Madam Chair.
It was sent on the 21st of June at 11:02 a.m.
While Mr. Young is looking for that, I recognize Member Rolfe.
So for file 22020, which we're on,
Mm-hmm.
I'm looking on the task force minutes for June 7th. The action states that the task force requests that the police department provide copies of documents provided to Mr. Svernoff and lists other categories of responsive documents that they may have under jurisdiction, and to provide as a follow-up process an order that they turn over the body camera footage within 2 weeks.
Oh, and guess what? I found it. It is in the record. It's page 81. So Ms. Leger did include it. Page 81, and at the bottom of the page, it's 345. So, Mr. Svernoff, when you're looking at the agenda, and for item number 5, file number 22020, when you click on the attachments, if you go to, and I'm not sure how it'll appear on your computer, but when I'm looking at the PDF, starting at page 81, or if you look at the bottom of the page, it says number 345. That is the first page of this letter that was submitted that gives this the list with an explanation of what each document is, each responsive document. And this was sent by Lieutenant Toomey
June 21st.
on June 21st.
So what page was that?
So it's page 80, because it's page 81 of the PDF. So at the top, it says City and County of San Francisco Police Department Headquarters. The date on this document is June 21st. And it says, Dear Sunshine Ordinance Task Force. And it's a 2-page, I take that back, 3-page letter signed by Lieutenant Toomey. Members, are you also finding this?
Well, on page 55, I see a letter from SFPD dated May 12, 2023.
So keep going to it's page 81 of the PDF. At the bottom of the page, you'll also see it stamped 345, and that's because if you compile together all of the packets that are part of the agenda, it's further into the packet, but because we break them up into PDFs, the PDF with attachments for item 5, if you go to page 81.
Well, on page 1, that's...
If you're looking
at the top, Madam Chair, at the top, it should say 81/140.
Yes. So, Mr. Zvernoff, if you're looking at the actual, right. So if you're looking at the near your scroll bar, if it tells you, which page you're on, it's 81 of 140. But if you're looking at the page numbers on the bottoms of the pages, it's page 345.
I have only 168 pages.
Okay, so when you go back to the agenda, we're looking at item number 5, file number 22020. When you click on the attachments link on that specific file, it should come up as there's a string of letters and numbers, and at the end of the URL, it says item5.pdf. This particular PDF only has 140 pages. The first page of this PDF at the bottom is numbered 265. If you're looking at a PDF that at the bottom of each page has numbers that are lower than 265, I think you might be looking at the wrong PDF.
I don't have beyond 265. I'm looking at the.
So in the URL, what are the last at the end of the URL before PDF? What does it say in your URL?
At the very end, it says item 5.
Okay, good. So if we scroll down on this, so if you're at the top of the PDF, the first page at the bottom of the page says 265. Do you see that?
Well, the very first page for me is 266 at the bottom.
Okay, at least you've got that. If you scroll down, or if you scroll down,
265. I have 265.
okay.
Yes.
Okay, if you scroll down to 345, which I know is a ways down, 345, the letter from Lieutenant Toomey sent on June 21st begins with the page number at the bottom of the page 345.
Well, so one of the things it says that they have not provided the CADs. They say advise how to contact Department DM, which I presume stands for Department of Emergency Management. Yes, the task force has instructed Lieutenant Toomey to provide those CADs, to provide those records, and their statements here just say that they're not refusing to provide those records on the ones that are listed on page 345 under Roman 1 and 2.
So
then it says not a party to the criminal record, thus not authorized to have the report. Again, there is a there are no records released.
So and Member Wolf, I believe you pointed this out, in our order of determination, we requested that this list be provided. Is that correct?
Yes, it's in the,
Okay.
it's actually in the description on the agenda. It's correct.
Yep.
Okay, that that
It doesn't mean that
a list of other categories of responsive documents that they may have under jurisdiction.
Mm-hmm.
And there's a follow-up process that they turn over the camera footage. It doesn't, the only thing it says above that is that it requests the SFPD provide copies of documents provided to Mr. Serrano.
Well, but
Okay.
that's up to the compliance committee to consider whether the fact that they refuse to provide CAD number 212652614 and 21265235543, that whether this is a violation. That's a public record in the custody. They
That's
actually
not what the order was.
Okay, hold on. Let's I think it'd be helpful. Can we go item by item just so we're not missing anything? Because I know Mr. Smirnov, you're so much more familiar with these things that you can jump to one and you immediately know what it is. Are we satisfied with items 1 through 4 are addressed in the December 19th letter, which they refer to at the bottom, where they released several hundred pages of documents to you. So we understand this part, yes?
Satisfied with what? They say essay explanation at the end of document. I haven't gotten to the end of the document.
Okay.
And
It says December 19th, 2022 letter. In an attempt to exhaust all reasonable attempts to locate documents regarding the complaint, SFPD conducted an arduous keyword search of the names provided and produced 607 pages of email documents on December 19th, 2022. An individual's person name could be retained in the following documents during the regular course and scope of police work, and it is in these documents that we can make a reasonable attempt to. Now I'm.
Well, first of all,
Yes.
this is something that just comes up. I think this is just completely wrong procedure to make me read this document during the session and make me provide a response on the fly. I have to check whether I have the 607 pages. Okay, asking me to do it on the fly, whereas when the committee is meeting, is patently unreasonable. They have provided this thing without me knowing that, without any of you knowing that this thing has been provided. None of you knew that this has been provided. I didn't know about this provided. No notice of this has been provided to us. Neither you nor me. Asking to do this on the fly is completely wrong. I will want to go and check whether I have 607 pages. I'm not going to take it on face because I want to really check these records.
Okay, I'm going to ask Lieutenant Toomey. Thank you for providing this, which is what we requested. Regarding, actually, do you, if you'd like to open with any comments on what was provided here and why in certain cases, if you could explain a little bit about the CAD numbers and advised how to contact DEM, and then the one where it says not party to the criminal record, not thus authorized. If you could explain a little bit about those, that would be helpful.
Certainly. The CAD numbers, the first two CAD numbers that are listed are CAD numbers that were entered by the complainant into the system. They were identified as CAD numbers, and then he was given the information on how to contact DEM. There was one CAD number in item number 19.
Mm-hmm.
CAD number in item number 19 was actually the file number that we just completed here. And that was the one that we were ordered to go and actually retrieve the CAD itself from DEM. And we did that, and we contacted DEM, went and then redacted the information and went outside the normal course of business, which would be to direct the individual to the custodian of records, because we were ordered by the compliance committee to do so, or I don't know if it was the compliance committee or the whole task force.
It was the whole task force. And so
Right.
that was for the body worn cameras. Number 19
No.
refers to those. No.
No, number 19 was actually the one I got confused. Number 19 was the last file number where we were ordered to provide a CAD.
Yes.
And so we went and obtained a copy of the CAD from DEM, and with them went through the redaction process. They guided us through what was supposed to be redacted because we don't normally produce CAD. And we produced CAD for the December 7th order on December 19th. So the first two CADs that are in number 6, section A, little I, and 2 little I there, those two CAD numbers, we were never asked to go above and beyond. We recognized that they were CAD numbers, and we provided the complainant with the contact to DEM so that they could get that information themselves. That was the last we heard of those two CAD numbers. So that can kind of address the CAD number issue with regards to those two. The case number starting with 050, if it's an online request and we cannot connect the individual to the criminal case number, we cannot release that because they're not a party to that police report and that criminal record. And he was advised to provide a release or show some type of connection to it so that we could release it. That was an automated response that was provided to him. You can then see that 1, 2, 3, 4, 5, and then a second time, 6, 7, 8, 9 other police reports were requested and were produced to him. Then that final one was, again, we could not link the requester to the actual police report, so we weren't able to discover that, but we did give them the follow-up information that would allow him to be able to get access to it if he could show that he had a right to it with regards to the criminal investigation of it. With regards to number 7, there are no investigative files outside of the basic police reports, so we did not have any investigative reports. Number 8 is no responsive records. 9 and 10, 11, 12, 13, 14, 15, 16. We have a right to maintain privacy of other individuals and their criminal history, so we cannot provide criminal histories of individuals that are not them. We're prevented from releasing that. That was described and advised to the complainant on the 16th of February, 2022. Again, calls for service, there was a request and we directed again to DEM to provide calls for service. That I remember that request, number 17's request, was worded phone or other calls involved or related to the said 4 individuals. We interpreted it calls to be calls for service, but we did note that we don't have any responsive records regarding internal calls regarding those 4 individuals. So even though we interpreted it as DEM and let them know how to go into DEM, we have no responsive records with regards to any internal calls or records regarding that. 18 again was CAD files request, and that's a DEM document, and we provided him how to get hold of the DEM. Number 19 was the order from the task force to provide that specific CAD number, which we did. Number 20 is body-worn camera footage, which was provided on June 9th and June 27th, today. 21 through 23 were, again, no responsive documents. They were looking for calls for service and CAD information, I believe, so it was to DEM. 24 was no responsive documents. And then 25 was a odd request with regards to interactions at the San Francisco International Airport. And all documents are actually handled by San Mateo County. And we provided information on how to get information through the county's Hall of Justice there in San Mateo. Lastly, again, we can easily and regularly search for police reports, investigative files, body-worn camera footage. The search of keywords for email was actually an arduous search that asked our technology department to take time out of the scope to pull the 607 pages and then having to review those pages to ensure that there was nothing connected to them that needed to be redacted. So to say that we've done our due diligence to review all possible searchable documents, I hope that the task force, or at least the committee here, can see that we've tried to do our best to categorize what we've been able to do and accomplish, and hopefully answered your questions.
Thank you. This is a very thorough, detailed response. I just want to verify, and I believe you've told us before, but when you were referring this petitioner and others to Department of Emergency Management, it is because they maintain those files and the police department does not maintain those files. Is that correct?
That is correct.
Okay. And regarding the items where criminal history requests, if that must be requested either by the individual or the individual must have a authorization from the person who is named in the whose criminal history is being requested. Is that correct?
That's correct.
Okay. Members, do you have any questions or thoughts about this about this response?
None for me.
Same here, none for me.
Members, are you satisfied with this response?
I believe so. It seems to meet the order of determination that we had, especially given that the body-worn camera footage was provided as related to the last file.
Okay. Mr. Zvernoff.
Yeah.
I'm sorry that you didn't see this letter before, because I know it would have been helpful to you to have been able to review it before. It was contained in the packet, but believe me, I understand how difficult it is just because of the volume of documents contained. We do our best, and our administrator really strives to put things in order so it's clear to everyone, you know, what is added later on. But having gone through this, do you, and I know ideally you wanted to receive all of this from the police department, but do you understand what you would need to do to make these requests to Department of Emergency Management to get the records that they maintain?
Okay, it's very difficult to do it on the fly during the live session, to listen to presentations and be able to respond. But here's one thing I can say.
Okay.
As far as items 19 through 16, the key word in there is considered criminal history request. And that's the task force has deliberated and has reprimanded the Department of Police Accountability as artificially narrowing down the request. I did not make a request for criminal history. It's the Department of SFPD decided that there's a request for criminal history. I specifically said all the records concerning myself and members of my family. I never mentioned that there's a request for criminal history. But in order to thwart my request, they said they will consider it. And in the same thing they did in 17, they interpreted this. That is something they're not allowed to do. They cannot consider a request that seeks all records about an individual by saying that they consider this just to be a request for the criminal record. And that is something that one of the points that came up in the previous sessions of the task force, and the task force said that they have no right to do it. Yet they're doing it repeatedly, thumping their nose at the Sunshine Ordinance and at the task force. The key was here, considered. They are not. Please go back to my request and analyze it, and you will see that this is not a request for criminal history. And they have decided by narrowing down it in this way, they decided they don't have to respond to it.
Let me ask Lieutenant Toomey, other than other than criminal history or calls for service, what other categories of records might the police department maintain that would be responsive to the line items 10 through 17? If
well, my response to that would be that he's asking for records of arrests and detentions.
Mm-hmm.
I would, arrests and detentions are by their nature their criminal history. It would, I don't know how else to interpret records regarding their arrest other than that is attached to their criminal history. If we gave some type of information with regards to how or when somebody was arrested, that would be providing the history of their criminal activity. So I don't think we have it. I don't think we have any other. Okay.
Not detentions, all records, without narrowing down.
Okay, but the line items from detentions of, arrests of, with a number of different names, I don't know how else to interpret those other than when they're asking for records of a detention or records of an arrest. Those are of their nature records of their criminal history.
Actually, Mr. Zvernoff, I am going back to your original request, and in this, and I understand that the terms that the police department uses are not necessarily the terms that you would use or that members of the public would use. So, calling this criminal history, but I'm looking at the line items of what you requested. And line item 9 says detentions of Sergei Zvernov. Number 10 is arrests of Sergei Zvernov. Number 11 is detentions, and on. And those items 9 through 16 all begin with requests for information about either detentions or arrests. Now, again, you and other members of the public might not consider those part of a criminal history, but that's the categorization that the police department uses for how they maintain records related to those events. For number 17,
the law does not protect detention records from disclosure.
This is Member Wong.
Repeat that again. Yes, Member Wong, please.
Just to double check, because I thought that Lieutenant Toomey, you had said that if a person can prove that they are related to the criminal history record, or they are that person, that they can access that information. Is that correct?
Yes. And with regards to this individual and his request, we provided him a letter on March 17th showing him how he can get the information with regards to his criminal history maintained by the San Francisco Police Department, which is referred to as a San Francisco clearance letter. And so we provided him the manner in which he can get that letter for himself.
Okay. And is that letter, does it happen to be in the packet? Do you know?
I don't have a knowledge as to what that letter looks like. If I'm not mistaken, the clearance letter is actually produced by the San Francisco courts, but I can confirm that.
I'm not looking for a clearance letter. I'm looking for San Francisco Police Department records. I think this is what is being done is just thumbing the nose at Sunshine Ordinance and at the task force and making me go to other entities and other departments. I'm not going to do it. I demand the records held by the police department.
May I?
Yes.
May I?
Mm-hmm.
There are no other documents in the San Francisco Police Department's possession that contain this individual's name or the 3 other names that we have free and open access to that we have not provided to him or given him direction on how to get. Yes. With the exception of 2 emails that we have already stated we are exerting our attorney-client privilege with. So,
Mr. Zvernov, when actually there's a distinction here between these records where you need to get that clearance, the task force and other individuals cannot get access to these records because they involve you or they involve, what is called criminal history of these other individuals. That actually is protected.
It has a clear definition of criminal history. It's convictions and sentences. This is in the California Criminal Code. Other things are just completely spontaneous interpretation of that racist to me, and things are in the custody of police department should be disclosed. When he says they went out and got
hold on, Mr. Zvernov, I need you to hold on for a second. Member Wolf has a question. Member Wolf?
I just want to refer you to 6721C, the last sentence, and I quote: "A custodian of any public record, when not in possession of the record requested, shall assist the requester in directing a request to the proper office or staff person," unquote. It's exactly what they did.
Yeah, I mean, exactly. Mr. Zvernov, I know you want these documents from the police department. I know you want them from the person you originally requested them from. Because they're not able to satisfy that, they're trying to point you to the specific places where you can gain access to these records.
Detention records are criminal records. They are not. There is no crime committed during detention. There are not parts of the criminal history. The state law defines what criminal history is, and it's the sentencing convictions and post-conviction results. These are things about the San Francisco Police Department arresting or detaining somebody. There may not be any crime committed at all. So they are interpreting this in a way that one day they want to interpret. I want the records that they have on arrest and detention, and not only this, all other requests, all other records. And my letter says,
Chair, can I call for decorum, please?
Yes.
Feel like
Yes.
this is disorderly conduct. We have not asked Mr. Severinoff any questions, and we need to carry on with this hearing.
Thank you. I'm going to, Lieutenant Toomey, I just want to verify again for the record, as far as the police department is concerned, information regarding arrests and detentions is maintained as part of what you call a criminal record. Is that correct?
Yes.
Okay. Thank you.
Whether they are
Mr. Zvernoff, I'm not asking for your comments at this moment. If you could just please wait. I'm just trying to get clarification. We're trying to understand what these terms mean. You may not like what the terms mean, but if we can get clarity on, if we can get some clarity on definitions and terms, it will make it easier for you to access the records that you're looking for. That's all we're trying to do at this time.
These terms are defined in state law, not by Lieutenant Toomey. Whether he decides to define it is completely irrelevant. It's defined by the state law.
Mr. Zvernoff, in fact, I can read you something because I was looking this up. And in fact, according to state law, arrest, detention, disposition, and personal identification information when submitted to, I mean, there is information that I found very quickly online that supports what Lieutenant Toomey said. So I don't have any reason to,
They are not exempt from disclosure. They are not exempt from disclosure.
Mr. Zvernoff, I need you to take a moment.
Madam Chair,
Yes.
please. Just a point of order. We are not necessarily authorized to be able to make a determination on that layer of law. Okay, that is something that I would want confirmation from our legal counsel.
I would agree.
Okay? I'm not a lawyer. I don't know how those documents or records are handled because they are controlled by not the Sunshine Ordinance. They're controlled by some other section of law. So I feel really uncomfortable about trying to make a determination of the nature and the status of that kind of record.
Member Wolf, what would you propose then? And I would like to acknowledge that Lieutenant Toomey responded to what we requested, responded to our request to provide this list. If you think that we need additional guidance from our attorney on whether, if you think we need additional guidance before closing this out, I think we should discuss that. Is that what you're proposing?
Well, it can be one of two things or both. One is, yes, continue the items so we can get clarity from our legal counsel, which I think is pertinent. And the second is really, it's up to the respondent to tell us, what those records, if they're being exempt or if they're being withheld, under what section of law that is. Okay, if the petitioner, the complainant, is going to cite some law saying that these records should be disclosed because of this particular law, it has to be within our jurisdiction. If it's not within our jurisdiction, or if it's not painfully clear with some other, like we've dealt with this stuff with HIPAA, with health records, and we've had to get confirmation from other departments as to whether those records are actually disclosable or not. But it's not up to us. HIPAA is not our jurisdiction. So, we have to seek other confirmation about other areas of law. And I don't feel comfortable doing that. That's why we have jurisdiction hearings.
Okay.
So
Please go ahead.
I would, again, my suggestion is that we continue this. If it's in the interest of this body, I would say continue the item. Let's engage legal counsel on the veracity of the nature of this particular category of record as to whether it is public or not, and whether it's within our jurisdiction to order it to be or have it compelled to be disclosed.
Okay. If we're continuing this, I would like to limit it to just that, seeking advice from legal counsel on this set of items regarding what has been categorized as criminal history, which requires a release of the individual, that it needs to either be requested by the individual involved or
Chair.
Yes, Lieutenant Toomey.
Chair, if I
Yes.
may.
Mm-hmm.
The reason why we responded with that and not, we don't have anything regarding those individuals. We can't direct that gentleman, though, to get a clearance letter for those individuals because he is not those individuals. So our standard response when somebody asks for criminal history of somebody that it's not them and is not authorized to them is to let them know that we determine that as a request for criminal history that we cannot give them. So I'm comfortable telling you, we don't have any documents for those individuals, but I can't direct that gentleman to get a clearance letter and obtain a clearance letter for those individuals because we don't know who he is in relation to them. We do know who he is based on his name, and we directed him to get his own clearance letter. So the idea of, and I understand wanting some clarity, we're not withholding anything. There's nothing we're withholding from him.
So are you
We're
saying,
just telling him we don't have anything from we are prevented to release anything even if we had it, but we don't have any.
so there are no responsive records?
I think
for
None.
racist
11, 12.
Lieutenant Toomey has completely got off the rails. He just lying that they're not withholding. 3 minutes ago,
No,
he said they're
we're not.
withholding.
Mr. Zvernoff,
Nope,
hang on.
nope.
We're trying to get some clarity here. Lieutenant Toomey,
Mr. Young, I just want to let you know I did conduct a muting. I did mute. Please let me know when you want me to unmute, as interruptions are not allowed without. My apologies. I don't know what words to say, but Mr. Surov is muted. Please let me know when to unmute him.
Okay. Lieutenant Toomey, you're saying line items 11 through 16, there are no responsive records, but if there were, it would require a release by the individual named or some, is that what you're saying?
Correct.
Okay. For items 9 and 10, are there responsive, or I guess,
We could produce a record which is referred to as a clearance record for the individual if
Okay.
he requested one, and we provided him the information on how to obtain one of those.
and so he would obtain a clearance record and then come back to the police department, and then you would release those records to him.
No, the clearance letter is the record that we can produce for him. If he wants to know what his criminal history is in the city and county of San Francisco, he goes and requests a clearance letter, and we gave him the instructions on how to do that. That is a record that has to be produced. We don't maintain it. We create it upon their request.
Okay. And it's
called a clearance letter. We cannot direct him to get clearance letters for other individuals without you can't do it for somebody else unless you have authorization from that somebody else.
And when you say a clearance letter, is a clearance letter something that describes the existence or lack of criminal history records with your jurisdiction?
Within the city and county of San Francisco, a state criminal history, because the way government works, we do not maintain the state criminal history. That would be the California Department of Justice. And we do not maintain the federal criminal history. That's the purview of the Federal Bureau of Investigation. So we can control and maintain the criminal history record of somebody for the city and county of San Francisco.
And when you say criminal history record or a clearance letter, anyone can request a clearance letter even if there is no evidence of criminal history within the city of San Francisco. Is that correct?
Anyone can request their own
clearance letter. Okay.
Correct.
Okay.
So after all of that and through this lengthy list here, again, the only documents that we are withholding from this individual has been referenced multiple times is the correspondence between the city attorney's office and the police department, which we addressed in the last file. That's it.
Okay. And the only way for him to receive his own clearance letters is by following the instructions that you gave to him.
That's correct.
And requesting clearance letters for these other individuals would return a letter saying there is no criminal history for this individual.
Correct.
Okay. Members, knowing that, even though there are additional technical questions that we could ask of our city attorney, since it doesn't seem to apply to records that it would not result in the production of any records, how do you want to proceed?
So let me just get clarification. If somebody requests their own criminal history records, they go to the police department. Police department will provide them with a letter or notice of clearance so they can get that. They can get their records. Where do they then go to get those records?
So the clearance letter would say that you have no arrests or have not been arrested or convicted in the city and county of San Francisco. To obtain your state criminal history record, you would go to the Department of Justice and request that you get a copy of that, or you would have to contact the Federal Bureau of Investigation if you want your federal criminal history.
But if there was criminal history, I mean, what is the purpose of the clearance to say that you don't have a criminal history?
That's correct.
Okay. So, but if there was criminal history, then what?
Well, I would say that in the city and county of San Francisco, you could probably contact the Superior Court of San Francisco to get the court filings for your, or you would contact the sheriff's department that runs the court calendar and does the calendaring of criminal charges that are brought against somebody. Or if a member of the San Francisco Police Department had arrested you, you could request the police report that lists you as being the individual arrested or detained.
Okay, thank you.
Okay. Members, I want to ask if you have any other thoughts. I do want to bring Mr. Svernoff back because we've just got, we received a lot of information, and I want to hear from him, but do you have any additional thoughts about how we would proceed given this new information? I guess my question is, at this point, would you feel comfortable dealing with this today rather than continuing the matter?
I'm not sure. I'm not sure where to go with this at this point, because I'm not sure what's being asked of. And Mr. Smirnov is stating, and I believe he stated that in this particular case that he was detained, so there was no criminal history. So I'm not sure what that means, because Lieutenant Toomey is stating that there is, that he's talking about criminal history. So
if I may, I apologize. Like I mentioned, any criminal activity that was interactions with the San Francisco Police Department would have been documented with a San Francisco police report. The complainant has requested certain police reports in which he is named, and we have provided those to him. So, again, there are no police reports in our possession that have this individual's name on it that he has not been that he has not requested, and we have not provided to him.
Okay. All right. Thank you, Madam Chair. Just as a point of personal privilege, I need to leave in 5 minutes.
Okay.
I will seek to return to the meeting before 8:30.
Okay. Mr. Young, if you could, I'd like you to unmute Mr. Smirnov, because I do want to give him a chance. I'd like to ask him some questions. If you could please unmute him.
He has been unmuted.
Okay. Mr. Smirnov, knowing that there are no responsive documents regarding the items you requested for 11, 12, 13, 14, 15, 16. There are no responsive documents there. Even though you could request clearance, or you could obtain consent to request clearance letters for these other individuals, but it sounds like that would be wasted energy for you, since it's not going to return any information. And you have instructions on how to do that for the items you requested in numbers 9 and 10. Is this clear? And do you understand what you would need to do here? I know it's not exactly what you want, but does this make sense?
Lieutenant Toomey is a racist liar. He is a avowed racist who sent racist messages.
Okay, Mr. Smirnov, here's the thing. I don't want to silence you, but I want to help you, and we need to move forward with this. Can you answer my questions?
My children have been detained by San Francisco Police Department, and during one of the detentions, one of the police officers has actually snatched a protective cast from my son's hand. San Francisco Police Department members have molested my underage daughter, and they have stated that she has been detained. So these are the records, the detention records that we're seeking. Mr. Toomey has not cited any clause or paragraph or part of San Francisco Ordinance or California law. All his statements are fake, lies, and a racist cover-up. I urge you to take legal advice. My requests were not about just criminal records and about all the records of persecution by my family by the racist San Francisco Police Department. These records are not protected, and when they state we are interpreting them as a criminal record, they are first of all misinterpreting things. Second, they are trying to cover up their racist misdeeds against my immigrant family. And if you're going to go ahead with them, you're participating in a racist cover-up. You cannot just take this 2-page letter and take a decision on it without analyzing it, carefully looking at the law and deciding what is wrong and what is right. Lieutenant Toomey is an evil and racist.
Okay, Mr. Zvernoff, I'm gonna stop you there. Lieutenant Toomey, I just want to ask the question regarding minor children being detained. Is that something that would appear in a clearance letter?
The detention of a minor child, no. A clearance letter states that they were not arrested or that they are free of any criminal arrests.
Where would the record be showing that they were detained at any point?
It would be if it was done by a San Francisco police officer, it would be in a San Francisco police report.
Okay. And does Mr. Zvernoff have the police reports that would contain this information about the detentions of his minor children?
Without having knowledge of what is the content of the police reports he's requested, I can say that the police reports that the police reports in which his name are listed in, he has been provided.
Okay. Mr. Zvernoff, do you have the police reports with your name in them that refer to the detention of either of your children? Do you have access to them?
No, I do not.
Okay. And were you also named in these police reports?
I have all the police reports that I should have received, and of all the detentions that I have been subjected to, I have only received less than a half.
Okay. I'm going to ask Lieutenant Toomey if Mr. Zvernoff believes there are other reports regarding incidents where he was detained and he doesn't have those reports. What would be the best way for him to identify the existence of those reports and gain access to them?
He has made a request, and we've searched for his name in our reports. We have given him all of the reports that we have with his name listed in them. I've personally searched for that gentleman's name in our report writing system, and if we have drafted a police report, I've cross-checked it with what he has requested in our portal and what has been provided to him.
Okay.
If he knows of other case numbers that he was involved with, he can provide those case numbers, and those reports can be located.
Okay. I'm also Member Wong, please.
Just to note that Member Wolf is absent as of 7 o'clock.
Okay, thank you. Mr. Zvernoff, for the incidents where you feel as though there are reports that you have not received, do you know the dates of these events?
I know approximately the dates of these events, and I know approximately of days when the police has entered my residence unlawfully, have taken a video and molested my daughter. And none of them have been provided.
Okay. Lieutenant Toomey, I do at this point think that, Member Wolf, at this point, do you think it would be more helpful for us to seek guidance from counsel than trying to continue? I mean, I have some ideas for what we could do, but do you think it would be more productive for us to talk to our legal counsel in trying to resolve this and making sure that the records that have been sought have been provided in a satisfactory manner?
Was that a question for Member Wolf? Because he's gone.
No, sorry, Member Wong.
Okay. Honestly, I feel like I could go either way. It's either we're trusting the word of what SFPD is saying regarding these records, or, we can have legal counsel weigh in. I guess I can see on camera no one is available right now for this hearing. Is that correct?
Yeah, we don't have anyone available for this hearing. No. I think in the interest of Lieutenant Toomey, I appreciate the documentation that you've provided here, and I believe you have provided what we asked for. Given that Mr. Zvernoff is not satisfied, I feel as though it's our responsibility to take it one step further and check with our legal counsel about whether we can advise any additional forms of searches, or whether our legal counsel might say that we have done what was required for this particular complaint, and it would be up to Mr. Zvernoff to file additional requests that were more narrow in terms of dates, which perhaps would make it might return additional responsive records. But at this point, I feel, since Member Wong and I are both have some uncertainty about this, I feel that we do want to continue this. I don't know that there's anything that we are asking. I don't think we're asking anything further of the police department at this point, unless you want to ask Mr. Zvernoff to provide a narrower segment of dates to do an additional search on the chance that you might find additional responsive records. But in the meantime, I think we need to talk to our legal counsel to get advice about how we can ensure that we've done all that we can do for compliance on this case.
I understand. I would just leave you with, when seeking that advice from legal counsel, just know that we have done a meticulous search of police reports, body-worn camera, and gone so far as to do keyword searches in our email, which is something that isn't done during the normal course and scope, and was outside of it, to ensure that we had tried to locate all of the documents that we might have with these names on it. I don't know of any other mechanism or search function to find documents anywhere else that are ours that we haven't been able to search and locate documents for. So when seeking your counsel, just please advise them that we're only retaining 2 documents that are attorney-client, and that is all that we have, because we have this wide berth of the request.
Okay. Thank you. Thank you for clarifying that. And I will take that information to our legal counsel. Mr. Zvernoff, I think this is all that we can do for this evening, because we don't have our legal counsel available. I am going to recommend that we continue this matter to our next Compliance and Amendments Committee hearing. I will come back with guidance from our legal counsel about whether this is as far as we can go with compliance, or if they have any additional recommendations for us to make specific requests to the police department. Even though I'm not making a motion here, I will call for public comment. Is there anyone in the room who'd like to make public comment? You can step to the podium. Otherwise, Mr. Young, is there anyone online or on the phone who would like to make public comment on this case?
Yes, if there's anybody who would like to make public comment, you can raise your hand at this time. You can use the application to raise your hand. I'm seeing no indication of other public commenters.
Okay, thank you. Mr. Zvernoff, Lieutenant Toomey, I'm sorry that we weren't able to resolve this in full today. I appreciate you being here and answering all of our questions. We will have this on our agenda again at our next Compliance and Amendments Committee hearing in August. Thank you for being here, and Ms. Leger, let's call the next item.
Item number 6, file number 22010, complaint filed by Ron Cicero against the police department for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner. On May 3rd, 2023, The Sunshine Task Force, moved by Chair Yankee, seconded by Member Schmidt, to find that the Police Department violated Administrative Code Section 6721 B as in boy by failing to provide records in a timely manner, send a letter to the Chief of Police to order persons most knowledgeable of property control and archived public records at 1995 Evans Avenue, and Building 606 at Hunters Point Shipyards to search for and turn over the requested records as soon as possible and to refer the file to the Compliance and Amendments Committee for follow-up.
Thank you. Mr. Young, do we have the petitioner and respondent here?
I do see the petitioner. If the respondent would raise their hand, I can unmute you.
I'm here. This is Ron.
Yes, that is our petitioner.
Okay.
I don't see a representative from the police department.
Is it Lieutenant Toomey?
He's not with us. He's not on the line.
Did he just drop off? Excuse me, Administrator Young, did
He's
Lieutenant
not on
Toomey?
the line. That's all I know.
He's not on the line. Oh my gosh.
And he knew this item was on here as well?
He should have. I mean, you know, we put together the agenda. It's certainly there. Lists the police department, and he got a copy of the agenda as, you know, and the agenda packet.
Let's start with Mr. Cicero. Maybe this is an easy one. Mr. Cicero, have you received anything from the police department?
I have not, although that's not entirely true.
I want the truth.
Okay, fair
Okay.
enough. I did receive a email response from Lieutenant Toomey that said he is not representing this matter for the San Francisco Police Department.
Okay.
It is still being handled by the Media Relations Department, and that I should contact Sergeant Lobsinger. Subsequent to that, I sent a letter to both Chief Scott, CCing Lieutenant Toomey, and to Sergeant Lobsinger, following up on the letter that was sent by the Sunshine Task Force, and did not receive a response. My first letter, which was sent to Lieutenant Toomey, because he was the one that was, I guess, CC'd on the original correspondence. I sent him an email on June 9th. He responded on June 9th, and he responded on Monday, June 12th, saying that he was not representing the matter. That same day, I followed up with Chief Scott, Lieutenant Toomey, and Sergeant Lobsinger. That again was June 12th. And there has been no response, to my knowledge, from the chief or anybody in the department, including Sergeant Lobsinger. So when I said there was no response, I basically got a response saying it's not my job. And that was the only response I got.
Okay.
I know that letter went to the chief. I sent
Madam
it out
Chair?
myself.
Yes.
Madam Chair, I'm just going to
Yes.
go ahead and unmute everyone just in case there's problems with hand raising again.
I think that's a good idea.
So if anybody is a party to this matter, just go ahead and speak up after I unmute you.
Do we have anyone representing the police department on the line?
No.
Yeah.
Okay, I did unmute everyone and there's no other responses. Had
Okay.
several people mute themselves again immediately.
Okay. Member Wong, how do you think we should proceed with this?
I mean, it sounds like we probably need to continue the matter. Without Lieutenant Lobsinger here, we can't get any updates. I don't know if it makes sense to do an email outreach to him specifically. Ms. Leger, I was curious, like, who did we reach out to, or in order to get a respondent for this hearing?
I actually reached out to both Mr. Toomey, Lieutenant Toomey, who is, you've heard for the first two matters. And I believe Sergeant Lobsinger was also included.
So they were both notified of this.
Yeah.
And did you hear back directly from, I mean, I know you heard back from Lieutenant Toomey about the other cases. Did he reference this? Or yeah, you know what, I can't speculate, but.
Without being able to see the records.
Mm-hmm.
Can I just say
yes,
that at this point,
mm-hmm.
it's very clear, because this has been going on since November of 2021.
Mm-hmm.
The SFPD does not want these records released. That there is no guesstimation there, or projection, or it's clear they don't want these records released. And it's my the project has now been sold, which means there's now a considerable amount of funding, which means I don't have to sit through another 2.5 hours, of which I just sat through, to try and get these records. It's also my understanding, after having now just spoken with an attorney, that the city is responsible now for my legal fees due to the time and lack of escalation. And I'm not an attorney, but I'm sure my attorneys now could explain this. And honestly, this has been tremendously frustrating, to say the least. As much as the last 2.5 hours were brutal, I can sort of understand where the gentleman was coming from.
Mm-hmm.
So if there's nothing else, there's no point in continuing this. I will take this up and I will file suit.
Are you choosing then not to, I mean,
what's the point at this point, right? I mean, come on. This has been going on since November of 21. This isn't your fault. I'm just saying, clearly Lieutenant Toomey knew this was on the schedule. A letter has gone to the chief of police. A letter has gone to others in the department, and nobody has responded. Nobody. So
Yeah, that letter to the chief I sent out myself.
Right. No, I'm sure it went out. I followed up with the chief.
Chair Yankee and I worked on it, so I sent it out.
Yes, of course. They have it. And like I said, I've met with them in person. I've sent multiple emails. It's been, what's going on, 3 years now? I'm not going away. Or 2 years, I should say, because it was November of 2021. So, I mean, we can continue this, but at this point, I think we all must agree it's a bit of a charade. And
yeah, I hear what you're saying. Member Wong, do you think there would be value in continuing this just to get a response from the police department about why they did not send a knowledgeable representative to this hearing as requested?
I mean, it may be just for our future purposes. I think as the Sunshine Ordinance Task Force, I think as Mr. Cicero mentioned, it's not going to get him what he wants. I think it's worth outreach, but not necessarily to continue the matter if Mr. Cicero is considering withdrawing it at this point.
Well, let's put it this way. I won't withdraw it, but I am going to take legal action because I cannot spend another 2 hours on the line like I just did. I will jump off a building. And I think you probably understand why.
Yeah, Madam Chair.
Yes.
May I suggest that we continue the matter to the call of the chair and ask that the petitioner eventually withdraw the matter in the future, and we will not schedule it until we hear further.
No, I think let's continue it. No, let's continue it. Because if I can take a multi-prong approach, then I'll do that. So let's continue it. The police department isn't here. Let's continue the matter. Maybe next time they'll show up, but I'm just letting you know where I'm at.
Okay, we appreciate that. Thank you. I do want to, let's continue this to the call of the chair. And Ms. Leger, let's request a response from, it sounds like if it's Sergeant Lobsinger who is responsible for managing this case, we would like a response, and we'd like to know why there was not a representative at our meeting.
And Madam Chair, if we do reschedule this, we can always attempt to put it as number 1 on the agenda.
That would be amazing.
I I would like to, even though we haven't taken a motion, as a matter of practice, I do like to offer opportunities for public comment. Is there anyone in the room who'd like to make public comment on this matter, or is there anyone online or on the phone who would like to make public comment before we move on?
If you'd like to make public comment, you can raise your hand by using the application at this time. Everyone is using WebEx at this time. I see no hands raised at this time.
Okay, Mr. Cicero, thank you. Thank you for keeping us updated. We'll let you know what we hear back from the police department. And Ms. Leger, please call the next item.
We do need the motion to continue to the call of the chair.
I'm sorry?
We need a vote on the motion to continue to the call of the chair.
So I made the motion.
We don't need a second. With only two people present, we don't need a second.
Okay. Can we please call the vote on continuing to the call of the chair?
Chair LaHood?
Aye.
Chair LaHood, aye. Member Wong?
Aye.
Member Wong, aye. Member Wolf, absent. Moved by Chair LaHood, seconded by Member Wong to continue matter to the call of the chair and contact Lieutenant Lobsinger on why there was no person most knowledgeable at the hearing.
Thank you. Please call the next item.
Item number 7, file number 23027, complaint filed by Maria Schulman against the Department of Police Accountability for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and or complete manner, and 6726 by failing to keep withholding to a minimum, and 6727 by failing to provide justification of withholding. This is the first time this matter is being heard.
Thank you. So this will be a hearing to determine jurisdiction on the complaint, and whether we have, if we have jurisdiction, whether we have all the information necessary to refer to the full task force. Do we have Ms. Schulman here, and do we have a representative from the Department of Police Accountability? Mr. Young, can you? Oh, I'm sorry. Go ahead.
This is Sarah Monder from the Department of Police Accountability.
I'm sorry. Could you say your name one more time?
Sarah Monder.
Sarah Monder. Thank you.
Mm-hmm.
And is Ms. Schulman on the line? Mr. Young, can you make sure that everyone has, or see if Ms. Schulman is there?
Sorry, I was speaking into a muted mic. I don't see her name listed on the list of people on the line with us right now.
Okay. I have two thoughts. Member Wong, we could either take a brief break, maybe until 7:30, and Ms. Monder, if you don't mind, see if Ms. Schulman is there then, or we could take the next item and just go out of order and see if she, it's possible she has stepped away. I know she knows this matter was on the agenda. Member Wong, do you have a preference?
I think I would prefer a break.
Okay. Ms. Leger, everyone else, let's come back at 7:30. So we are taking a short break. We'll be back at 7:30.
What time do you have?
I have 7:21.
that the one for you?
Hi, can you hear me? Yes.
Okay.
Is Member Wong there?
Yep.
Okay.
Okay.
Uh,
And Victor's there. SM.
Confirming that I'm here.
Sarah Maunder.
okay. So,
We have 2 members present.
yes, Ms. Leger, if you could, just as a formality, if you could
Read into the record again.
read into the record the time we're restarting and call roll.
All right. Our break has concluded. It is now 7:30 p.m. And I'm going to call item number 7.
Before you do that, if you could just call roll as a formality.
Okay. Member Wong.
Present.
Member Wong present. Chair LaHood.
Present.
Chair LaHood present. We have a quorum. Read the item.
Yes, please.
Item number 7, 23027, complaint filed by Maria Schulman against the Department of Police Accountability for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and or complete manner, 6726 by failing to keep withholding to a minimum, and 6727 by failing to provide justification of withholding. This is the first time this matter has been heard.
Thank you. Mr. Young, could you tell us if Ms. Schulman is on the line?
There's no change to our attendee list.
Okay. Unfortunately, I think
I will say that in reviewing the correspondence before this hearing, seeing what Ms. Schulman was saying, she's very aware that this case was being heard today. She gave no indication that she wouldn't be able to make it. So my conclusion is there must be some kind of emergency.
Okay.
Because she's generally pretty responsive to our hearings.
Okay. I am inclined to say, since I'm sure Ms. Maunder has been waiting for this item to come up, I think we should postpone this to our next hearing. And Ms. Maunder, I'm sorry that you've already waited to participate. We appreciate you being here. But I think we need to delay this matter, to postpone this matter to our next hearing in August.
Madam Chair, if you don't mind, I'm just going to go ahead and unmute our last 2 callers just to find out which items they're here for, just to be sure I'm not mistaken.
Thank you.
Ms. Lynch, can I confirm that you're here for item number 9 on behalf of the planning department? He's not responding, but I believe that Ms. Lynch is representative for the planning department.
Okay.
And I have one other person with us. Maxine, I was wondering if you can confirm which item you're here for. I have unmuted you. If you can just confirm which item you're here for. I'm not getting a response. Oh, there she goes. No, that's Mr. Pelpel who raised his hand.
Can you hear me now?
Yes, I can. We're just confirming who's here for which items.
Right, it's David Pelpel. I was just going to give you a suggestion that if you haven't called item 8, maybe you want to deal with that because it's another DPA item, and then maybe Ms. Schulman will show up, and if not, then you can continue that or whatever. Just a thought, that's all.
You know what? Thank you, Mr. Pelpel. That is a good idea. Since Ms. Maunder, are you going to be handling item number 8 as well?
Yes, I will be handling that one too. Thank you.
Okay. I think that is a good idea. Let's take item 8 first.
I'm just wondering if the representative, if the petitioner for item 8, if you are here, if you can raise your hand.
The petitioner for item 8 is in the room with us.
Okay, my apologies. I get used to being completely remote.
I know, it's exciting to have real people.
My apologies. Cheryl, if you can read item 8.
Item number 8, file number 23033, complaint filed by Andrew J. White against the Department of Police Accountability for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and/or complete manner, and 67.7A by failing to notice the hearing 72 hours in advance of the regular meeting. A policy body shall post agenda containing a meaningful description of each item of business, and 67.7B as in boy, by failing to provide meaningful descriptions that are sufficiently clear and specific to alert a person of average intelligence. This is the first time this item is being heard.
Thank you, Ms. Leger. Mr. White, I'd like to invite you up to the podium. Yep.
And are we allowing 5 minutes or 3 minutes for?
We're gonna do 5 minutes. As Mr. White is getting ready, I'll explain the procedure. So we'll give Mr. White 5 minutes to explain his case. Then we'll give Ms. Maunder 5 minutes to respond. Then we'll allow 3 minutes for rebuttals from each side. Actually, we'll take questions from members of the committee in between, and then we can do rebuttals, and then we'll proceed. So, Mr. White, I know you were getting ready, but what we're going to do is give you. Oh, is Mr. White's mic on? Could you speak into it again? Let's hear.
Hello.
Yes.
Hello.
Okay. Perfect. So, Mr. White, when you're ready, let Ms. Leger know, and she will start the timer and give you 5 minutes.
I'm just going to suggest you have the microphone as close to your mouth as possible so that we can get a good recording.
Okay.
Thank you. Are you ready?
Yep.
Ready, sir?
Just a second. Whoops. This P-pop filter. Okay. Yes, I'm ready.
Go ahead, sir.
Okay. Yeah, I'd just like to address. I have a complaint here that I put in revolving around 3 sections or codes. I suppose sections of the Sunshine Ordinance. Based off, I'm just going to address the complaint directly and the letter I received from the DPA, from their staff attorney. First of all, I mean, with all due respect to the DPA for working through this with me, I'm basically just trying to acknowledge some policy and procedure that may need. It's a little fuzzy to me. Maybe they could potentially take a suggestion here revolving around the complaint. I also, okay, so first of all, I submitted some documentation a couple days late, I believe, recently to Cheryl Ledger, maybe is her name. I'm not sure how to say her last name.
Don't worry about it.
Leger. So I don't know if that is admissible today for me. It's kind of a generic phone record, which I've already stated on the complaint to the DPA, which is basically what this is about. I made 2 phone calls to Helen Calderon in December of 2022. I have the dates listed. I had a couple generic phone records that really aren't going to say much because the dates aren't on them. But if the DPA did check, she was on vacation. That's what's going on. She's on vacation. So I called twice, one on the 21st of December, 2022, and one on the 30th of December, 2022, and she was on vacation. I just wanted clarification of some of the potential action of approach to locating potential officers regarding the original incident dating back to 7/7/2018. You know, they did try to help me in the beginning, them being the DPA, for trying to find some hospital records from that day that were not able to be located. And so I'm not understanding how they went about determining their findings of informational regarding how they tried to locate the police regarding the original instance, which is the misuse of a taser in a particular form and fashion of really probably is valid as a very valid candidate for SB2 of decertifying a police officer, being as that they ripped my pants off while I was handcuffed and put a taser somewhere where it shouldn't be, to the bare skin, and which is kind of odd. I mean, I don't know. I'm not going to get too far more into that. I'm going to focus more on policy and procedure, but this did occur, and there were EMTs and many police present, so there were plenty of witnesses of them doing this to me. So I just recently attended an ACLU meeting revolving around SB2, which is talks a lot about POST, which I've learned about POST, Peace Officer Standard Training courses, and decertification of police officers. So I'm trying to get informed on in these departments here. So basically, I received a letter on this complaint. I referenced three sections of the Sunshine Ordinance, 67.21B, 67.7B, which pretty much kind of go together, and 67.7G, which actually seems to me to be a pretty easy one. Let's see here, pretty clear, and will help clear things up for others. Also, I see it in a lot of different entities placing this sunshine acknowledgement of your rights in their paperwork, so people are aware and don't forget that they can utilize this function. So the letter from the staff attorney of the DPA, James Conger, on the recent complaint that I put regarding the 2 phone calls I made to Helen Calderon revolving around clarification on how did they attempt to locate these potential officers who misused their taser? So I know they said they don't have records of the phone call. Here in the letter from James Conger that was sent to the Sunshine Ordinance Task Force on March 21st, 2023. They say there is no record of the phone calls on their end. Okay.
Your time is up
For what?
for speaking.
For speaking.
Completely?
Yeah.
Don't worry.
We'll ask questions.
Okay, go ahead.
So what we're going to do is give the respondent 5 minutes to talk, and then Member Wong and I will have questions for you. So when we ask you questions, you'll be able to give us more of the details that you didn't have time to give us in the first presentation.
Okay, sounds fair. Okay.
So, Ms. Monder, are you unmuted?
Yes, can you hear me?
Yes, we're going to give you 5 minutes to speak, and then Member Wong and I may have questions for both you and Mr. White. But please go ahead when Ms. Leger says she's ready with the timer.
Okay.
Ms. Mounder, are you ready?
Yes.
Okay, great. Go ahead, ma'am.
Okay. So Sarah Monder for the Department of Police Accountability. I don't have much to add to the letter that we submitted previously in March. I'll just summarize and say that we have no record of a request for public records being made. And regarding the hearing, the complaint about the hearing procedures, there was actually no hearing. The hearing was denied. And so the manner in which the hearing occurred is not truly an issue because no hearing occurred. And so that's all I have to add. Thank you.
Okay. Member Wong, do you have any questions that you'd like to start with?
I think the first question is for Mr. White. I didn't see any request for public records. Was there a request made to DPA for public records? And if there was, how was that request made?
This is a question for me?
Yes.
Okay, am I eligible to answer it this time?
Yes, please.
Okay, thank you. I had made, per the recent complaint regarding 2 phone calls to Helen Calderon, I had referenced 67.21B and 67.7B. It states in 67.21 that you can, I believe, let me see here, you can use oral requests, 67, there's a statement 67.21B of the Sunshine Ordinance that oral requests can be made, I'm assuming over the phone. So I left a message twice. Conrad was on vacation both times. From the sounds of it, it's the holidays. So that is what I did, and I feel I would. So my request for investigative hearing, yes, was denied. So I'm just wondering, since there's no record of these phone calls from me, which I did. I have a generic printout from my end, but I was hoping I could match up the times on those generic printouts on your end. But they're saying there's no records of them per your letter, March 21st, 2023. So I'm wondering if I can, in the future, utilize California Penal Code 632 revolving around, I may have to do this on occasion if I do go through this again, this process, to record on my end the conversations or messages being left. I just wanted to put forth that potential effort, cause that potential action in the future. So I don't know like how your department records the conversations, but I believe it is going to be necessary for me to try and do some of that on my own. When I call, and I just want to be aware of that. I wanted people to be aware of that. I don't know if I'm going to be doing that every time, but things like this, it sounds like I need to.
So I think there may be a bit of confusion here. So the Sunshine Ordinance Task Force, our jurisdiction
Oops,
is
sorry, who is speaking right now?
This is Member Wong.
Member Wong, okay,
She's
okay,
attending
thank you.
the
I
vote.
was confused with
sorry about that.
Monder Wong. Thank you, Wong.
Yeah, our jurisdiction is around public records and public records requests, and it sounds like your main complaint may have been specifically in a request for an investigation by the DPA. Is that correct?
Yes, just how they went about in terms of gathering their findings, which were informational. I just was more curious as to, how the paper trail transpired, and maybe not all the details, since my request for investigative hearing was denied. But kind of just a general layout of did they approach any of the companies, any of the precincts, any potential officers that I may have listed. And that is all. However, I would like to try and, the documents I did submit revolving around this complaint, I would like to try to redact a few of the documents, except for the complaint, the main complaint, and item 1, defining the complaint that I submitted. And I'm gauging this off of, modified anonymity, public anonymity from 67, Sunshine Code 67.21K, client, attorney-client privilege type thing, which would be me here. So, and then, SB 16, SB 1421, leading into 832.5 penal codes revolving around anonymity and redaction. I'd like to, so it's not all online. I'm just putting that request in.
Mr. White, that's an interesting question. Unfortunately, because you submitted the records for this, for this hearing, these documents, this was posted online.
It's already been posted online?
It's already posted online.
Okay. Well, how do I redact that? I believe I should have the right to do that, stating the laws that I just cited. And since the police department seems to have a lot of.
To be honest, we have never had. I have not encountered this request before. I think we would need to talk to our legal counsel about that. I don't know, and Member Wong, unless you have further other advice on this, since it has already been posted as part of the public record, because when this meeting was announced, we posted an agenda, and it included attachments that were documents, including information submitted by you, the petitioner, and by the respondent. Okay. Ms. Leger, Mr. Young, I don't know if you have any guidance on this, or if we just need to talk to our
The-
counsel about
He needs
that.
direction on how to submit records. Is that
No.
One of the letters is
He-
incomplete also, that's why, but.
Yeah, so he submitted documents supporting his file here that he doesn't want to be online, but they are already online as part of this agenda.
I will speak to my supervisor, Alisa
Okay.
Samara. She's the only one with authority to remove something that's been online.
Okay, so Mr. White could follow up with you
Yeah,
about
you
that.
can. You can just
Okay.
email me. I'll talk to her tomorrow. What's tomorrow? Wednesday? Yeah, Wednesday or Friday, because I have appointments on Thursday.
Okay.
But I will be in touch with her, and I think I have your email address, so she and I will just talk about this, and once that's taken care of, I can let you know.
Okay.
You have to be specific about what records you want removed.
Actually, I'm glad that you've made that connection. Let's continue back with the case, but thank you for answering that because I did not know how to proceed at all
Yeah.
regarding that request. Ms. Monder, I have a question for you. Or sorry, actually, Member Wong, did you have additional follow-up questions?
I don't.
Okay. Ms. Monder, I have a question for you.
Yes.
So you said that you don't have, were you able to check phone records or check regarding voicemails, Ms. Calderon's voicemails, whether she received these voicemails that Mr. White says that he left for her on late December?
I believe that, James Conger, who used to be on our staff, searched for records, and I believe before he left, he told me that he asked Ms. Calderon verbally, because it wouldn't be a practice to save voicemails, but we would say, so Helen is an investigator, Ms. Calderon was an investigator, and if she received a voicemail, the standard practice would be to record the contents or document the contents of the voicemail or the request in our case management system, and we couldn't find anything documenting a phone call, and she did not remember getting any public records requests. So it may just have been discussions about, and then this is speculation, about the findings letter and the request for an investigative hearing that was denied.
I'm sorry. So you're suggesting, actually, are you saying that that she had conversations? Are you suggesting that Ms. Calderon had conversations with Mr. White rather than receiving voicemails?
I don't know if she received a voicemail. I'm assuming because Mr. White said that he left voicemails that Ms. Calderon did receive them. So I didn't personally question her. But we don't have the voicemails anymore. So I'm assuming that the calls were about the findings letters that were sent. It's fairly common when a findings letter goes out for a complainant to call back and ask what the findings letters mean.
Okay.
And how to request an investigative hearing. So an investigative hearing is the next step after our findings letters go out. The next option a complainant has is to request an investigative hearing. And so very frequently at the end of an investigation, there will be a conversation about how to do that.
Okay. But Mr. White made a request and that request was denied. Is that correct?
Correct. The request for the investigative hearing was denied.
And was that request made after he says he left these voicemail messages, or that was made before he said he left the voicemail messages?
I'm not sure.
Mr. White, when your request for a hearing was denied, what month did that happen?
The request for the hearing being denied. Let me see if I have that up here with me. I have it somewhere. I think it's over there, though. Can I go grab that?
Sure. Actually, Mr. White, I found it here
I'm
in the
looking-
record.
I'm not finding it in here.
So I believe that,
I'm looking for the denial letter is what I'm looking for.
yeah, it looks like it was in 2020.
Yeah, because I mean, I do have documentation. It says request for an investigative hearing will be granted by the director to individuals who demonstrate a hearing will facilitate the fact-finding process. So this is like before I got there, but yeah, this was.
And it sounds like, and Ms. Monder, if you could, is this correct that the Department of Police Accountability did not find enough information to proceed? Is that why the request for hearing was denied?
Yes, that's correct. If there is no new evidence, then an investigative hearing is not granted.
Okay. So it sounds like the Member Wong, how do you think we should proceed with this?
I'm not sure. I've never been in a situation where we don't have specifically a records request.
Yeah, I mean, it's there was all we know at this point. I mean, we know that Mr.
I
White,
found it. Denial letter.
and was it in 2020?
September 18th, 2020.
Okay.
Request for investigative hearing denial.
Okay.
From Paul David Henderson.
So, what we know is that Mr. White says that he left voicemail messages. And Mr. White, you didn't hear back from. Did Ms. Calderon call you back at any point after you left those voicemail messages?
Not to my knowledge, unless there was a technical difficulty on my end with receiving the phone call.
Okay.
But I don't believe so.
But unfortunately, the Department of Police Accountability doesn't have.
Alex left my email. Sorry to interrupt.
Yeah, no, it's okay. It according to Ms. Monder, Department of Police Accountability doesn't have a record of those phone calls. They don't maintain voicemails, but they don't have notes from Ms. Calderon about receiving that call. I don't know how we would proceed at this point because it doesn't. It seems that would be the only issue that we could proceed with. I know you had some suggestions about the procedures of the Department of Police Accountability, but I don't know that those are. I don't know that those are relevant to the Sunshine Ordinance. Unless Member Wong, do you think there's anything that we're overlooking here?
I don't believe so, because I think some of those refer to public meetings, and I don't think that the DPA has public meetings that I'm aware of.
Ms. Monder, does the DPA have any public meetings?
We do not, except for during budget cycle.
Okay, and that's not the type of meeting that Mr. White was concerned with. Is that correct?
Correct.
The meeting that I was concerned with, which may not have occurred, was the attempt to locate the officers, whoever they may be, revolving around if they had any type of contact or conversation with any precincts revolving around the vicinity of the incident. Because I did state in a letter that is incomplete online, the one I was talking about redacting, because there's more than one page, first of all. But anyways, so I don't know if anything was done outside of in the very beginning trying to find a hospital report that wasn't there. 67.7B, and that's what I'm referring to with 67.7B, alerting a person of average intelligence, being a meeting between the DPA and the PD is what I'm referring to. Did this occur? I don't know.
Unfortunately, I don't think that falls under the scope of I'm a meeting you're describing, which would be communications, the investigation work done between those two departments. That wouldn't be a public meeting, so I don't think that's something that I don't think that falls within our jurisdiction. I feel it seems as though the one thing that might fall within our jurisdiction is the lack of response to the requests you made over voicemail, but I don't know that we have enough evidence to proceed with that since there's no record with the Department of Police Accountability of those voicemails being received. So I don't know how we would proceed with this.
Okay, and it just says made available for public inspection. Basically, information revolving around the item, the complaint. I'd imagine. This is 67.7B, and the last sentence. This is the last sentence. It shall refer to any explanatory documents that have been provided to the policy body in connection with an agenda item. Policy body, maybe the DPA, the agenda item be my complaint, or the Sunshine Ordinance Task Force in my complaint, such as correspondence or reports, and such documents shall be posted adjacent to the agenda. Adjacent to the agenda. I don't know if this is considered the agenda. My terminology is straight. If such documents are of more than 1 page in length, made available for public inspection. Now I'm confused there whether public inspection is me being a member of the public and being able to inspect it privately before it is put forth for the rest of the public.
I think the problem is, and I'm going to verify with Ms. Monder again. Ms. Monder, the Department of Police Accountability does not hold public meetings or post public agendas. Is that correct?
That's correct.
Except for the budgetary meetings. So what Mr. White is asking for regarding publicly posted agendas don't apply to your agency.
That's correct. We don't have any publicly posted agendas.
Except for the budgetary meeting, which is not what Mr. White is inquiring about.
Correct.
Okay. Mr. White, unfortunately, Member Wong, do you see anything that falls within our jurisdiction where we would have enough information to proceed with forwarding a complaint to the full task force?
Unfortunately, I do not.
Okay. Ms. Monder, is there any other advice that you would have for Mr. White that might help him in gaining access to information that he's looking for?
For this case, so basically his rights to information when he makes a complaint derive from his status as the complainant, as opposed to a member of the public. And so the options available are requesting a case review and requesting an investigative hearing. So the only two options are, once the complaint investigation has concluded, is to request a case review or request an investigative hearing.
And has he already done both of those things?
I believe so.
Does Mr. White have an option to request another case review, or how would the Department of Police Accountability respond to him requesting another case review?
Generally, you only get one case review, but I can see the confusion that occurred here. And if, say, he requested a case review before but didn't actually exercise that right, we can accommodate that if he would like to request one now. Or not now in this hearing, but if you would like to contact the investigator for a case review and mention my name, I can facilitate that.
Okay, so would it be Ms. Calderon who he is reaching out to again, or would it be would it be someone else in the department who he is contacting?
Yes, she would be the person.
Okay, so Mr. White, at this point, unfortunately, I don't think we can help you here at the Sunshine Ordinance Task Force, but Ms. Monder is suggesting that you contact Ms. Calderon again and request a case review.
Okay, yeah, that sounds great. I mean, I do understand that there are options for people to, take classes, become mediators and all that stuff. And the case review, I was aware of that in the beginning. So that's great. I mean, the classes are, you got to pay for them or whatever. I applied, but I didn't qualify for whatever reason at this point. So I mean, the case review, I'm just curious to the DPA here. The case review, I appreciate that option to an extent. Is that going to, and I don't know, maybe this is wrong side to ask, does that mean if I get a case review now after the denial of the investigative hearing, I'm just going back for a case review and the investigative hearing option is eliminated still?
If you'd like me to, if the chair would like me to answer, I can.
If you can answer briefly, and then after that, I think we need to move on because it sounds like we're getting quite far afield from the Sunshine Ordinance, but please go ahead.
Okay, yes. Yes, so the opportunity for an investigative hearing has passed. There are strict statutory limits for investigative hearings and discipline for officers. So what you would gain from a case review would simply be an understanding of what happened during the investigation.
Okay, thank you.
You're welcome.
So at this point, since we are not going to recommend that this be sent to the full task force, Mr. Young, do we need to make a motion to find, what motion do we need to make?
It may be a good question to ask if the petitioner would be willing to withdraw the complaint. If not, you can send it forward to the full task force with a recommendation that no violation has occurred.
Mr.
Or
White?
you have no jurisdiction, or whichever.
Member Wong?
Did they freeze? Or
Sorry, please go ahead.
oh, there was silence, so I wasn't sure if things were frozen because it looks like the video is frozen on our side.
May I interject a proposal revolving around this complaint that may fall under the task force jurisdiction, revolving around 67.7G, which is basically asking the DPA to implement this into their policy on the information, on the facts and findings, the final facts and findings, the results, in this case being informational, to squeeze in the 67.7G. Each policy body shall ensure that notices and agendas for regular special meetings shall include the following.
So Mr. White, so you're talking about agendas, and agendas are for need to be posted for public meetings. The only public meetings that they hold are their budget discussion meetings, which I don't think are the kinds of those aren't the discussions, the kinds of discussions.
For special meetings well, I mean, this is an agenda though for the task force to remind. I'm thinking of using this as a reminder. I've seen it in other. I can't remember where I saw this right now at this point, but know your rights under the Sunshine Ordinance, Chapter 67. Yes. I mean, is that like a wild request to put that in their paperwork?
Unfortunately, it doesn't apply.
If they don't like their findings and they.
So it does. So the investigations and findings that they're talking about there are not the same as what we're doing here in a public meeting. So I hear what you're asking for, but it's not within our jurisdiction to make that kind of recommendation for them for their procedures not relating to public meetings.
Okay.
So.
Okay.
I'm sorry that we're not able to help you further here with the Sunshine Ordinance Task Force, but I hope that in going back to Ms. Calderon and requesting a case review, she might be able to help you understand what happened with the investigation with your case, which is what Ms. Monder is suggesting. And I think that is most likely, I think that's the best avenue for you getting the information that you are seeking.
Okay. Yeah, that sounds pretty decent. I need to get your email or you're going to email me revolving around the online documents.
Requesting, yes.
Redacting
documents you removed.
Yeah. Well, actually,
not all of them, but some of them.
Mr. White, Mr. Young, who was also speaking remotely, wanted me to ask you, since we're not going to recommend that the task force proceed with this case because I don't think we there's a good application of the Sunshine Ordinance here. Would you like to withdraw your case, or would you like us to just send our recommendation to the task force that we not find violation? And that is, it's your choice.
So revolving around those two options, it's still all posted online.
Although Ms. Leger is
Last
going
time.
to ask her supervisor if she can remove those documents from the record.
Do you want your entire case file removed?
Or just the supporting documents, perhaps. It
Just the
sounded like,
supporting
I suppose with everything being discussed, it could all be removed.
I mean, Ms. Leger, I don't know. I think perhaps the complaint document, it didn't sound like Mr. White had issue with that. I think it was the supporting documents that he was concerned about.
Yes, that was.
Exhibits 1 through 5?
Yeah.
Just exhibits 1 through 5?
Yeah, the complaint. Yeah, I suppose so. Yes.
All right, we can move. I will talk to my supervisor. She's the only one that has authority to do that.
Okay. And
Madam
should I
Chair,
email you or
Yes.
wait?
Sorry, Mr. Young, yes?
I think maybe the best option would be to refer the matter to the SOTF consent agenda with the recommendation to find that the task force has no jurisdiction. I
Okay.
believe that was your discussion. My apologies if it's not.
Yes, I think that's what we're, I'm going to make a motion to forward to the task force consent agenda, finding no violation, or excuse me, finding that we do not have jurisdiction.
Seconded.
Okay. So, Mr. White, what we're going to do next is open this up for public comment. So that would be not from you or Ms. Maunder, but other members of the public, just to comment on our motion. Is there anyone either present here in person or online or on the phone who would like to make public comment on this motion?
If you'd like to make public comment, you can raise your hand at this time. I'm seeing no indications of raised hands.
Okay. In that case, Ms. Leger, could you please call the vote?
Chair LaHood?
Aye.
Chair LaHood, aye. Member Wong?
Aye.
Member Wong, aye. Member Wolf, absent. Moved by Chair LaHood, seconded by Member Wong to forward the item to the Sunshine Ordinance Task Force agenda with a finding that we do not have jurisdiction.
Okay. Mr. White, oh, yes.
Consent agenda.
Consent agenda.
Okay, that's what I have in my notes.
Yes. Okay, great. Mr. White, thank you for coming in today. I hope that you're able to get the information you're looking for when you talk to Ms. Calderon.
Okay. To who?
At the Department of Police Accountability, Ms. Maunder suggested that you follow up with
Calderon.
Ms.
Correct.
Calderon.
Okay. What was your name again?
I'm Cheryl.
Oh, you are Cheryl?
Yeah.
Okay. You're the one I was trying to pronounce the last name.
Don't worry about it.
Okay, sorry about that. It is. Was I close? I guess close enough for now. Huh? Okay, so I'll just deal with that then. Okay. Thank you.
And yeah, and Ms. Leger, if you could follow up with Mr. White and let him know, I think that would be helpful because we understand his request.
Yeah.
Okay.
Totally.
Thank you. Let's please, Mr. Young, can you let us know, is there a chance that Ms. Schulman is on the call?
Nobody else has logged in.
Okay. I would like to recommend that we move item number 7, that we continue item number 7, file number 23027, to our next Compliance and Amendments Committee meeting. And Ms. Leger, if you could follow up with Ms. Schulman and
May
let
I
her know.
suggest call of the chair just in case she cannot make the next meeting?
Sure. To be scheduled to the call of the chair. That would be fine.
And second is Member Wong.
I think since it's to the call of the chair, I think Mr. Young said we don't need a second on that, but we will take public
With
comment.
only 2 members in the room, there's really no need for a second.
Okay. But we'll see. Is there any public comment?
If you'd like to make comment, you can raise your hand. I see no hands raised at this time.
Okay, thank you. Ms. Leger, if you could call the vote on that.
Chair LaHood.
Aye.
Chair LaHood, aye. Member Wong.
Aye.
Member Wong, aye. Member Wolf, absent. Oh, let me see the motion. Moved by Chair LaHood, seconded by Member Wong to continue item 23027 to the call of the chair.
There was no second.
All right.
All right. Thank you.
Item 9 now.
Yes, when you're ready, item 9, please.
Item number 9, file number 23019, complaint filed by Olga Tikhanova against the Planning Department for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and/or complete manner. This is the first time this case has been heard.
Mr. Young, do we have Ms. Tikhanova and someone from the Planning Department ready to discuss this matter?
Yes, I have made everyone panelists so they can unmute their own microphones at this time.
Ms. Tikhanova, are you here? Do we have someone here from the Planning Department?
Yes, Laura Lynch from the San Francisco Planning Department.
Ms. Lynch, thank you for being here. Mr. Young, are there any lines that you have not identified or don't know who they are?
We have a Maxine on the line with us. They are unmuted.
This is Member Wong. I'm not sure if this is the case, but I know there's a Maxine Anderson who will be participating for item number 10. So that may be that Maxine.
Ms. Leger, did you? Okay, great. Thank you for letting us know. Ms. Leger, did you hear anything from Ms. Tikhanova indicating that she was planning on attending this meeting?
I actually didn't hear anything, but I do know she has had a total of 3 open cases, 2 of which have been heard by complaint committee. And then she did not make an appearance at either of those 2 hearings.
She did not.
She did not.
Okay. But this is the first time this one's being heard.
Yeah, all of her cases have not been heard, including this one, if she's not here today.
Okay. Since this one is separate from those, and this is the first time that she hasn't appeared for this, we need to give her the benefit of the doubt, check in with her. We're going to postpone this one to the call.
Madam Chair,
Yes.
I believe it's our standard procedure to go ahead and close it and give them 60 days to ask us to reopen it.
Even if it's the first time.
Yes.
Okay. I will accept that.
And
I will
Cheryl, if we have any more complaints from this person, let's not schedule them until we get active confirmation.
Okay. I'd like to make a motion that we close this case. Do I have a second?
We want to say to table the matter and per complaint procedure.
Okay, making a motion to table the matter per complaint
Procedure 7B
complaint procedure 7B
with prejudice.
Without prejudice.
without prejudice.
Without prejudice, yes.
And we will inform the parties, and they will have 6 days to request that the matter be reopened if they so desire.
And we will inform the parties that they have 60 days to request that the matter be reopened if they so desire.
Does that need to be part of the motion? I think that's part of complaint procedure 7B.
Yes, it does not need to be part of the motion, but we just state it for the record that they will be notified.
Okay.
All right, do we want to do public comment on this one?
Actually, I'd like, do I have a second?
Seconded.
Let's open this up for public comment. Is there any public comment on this motion?
Mr. Pilpil, if you want to raise your hand now, it's your time. He's our only person left on the calendar. No hand raised. We can close public comment.
Okay, please call the vote.
Chair LaHood.
Aye.
Chair LaHood, aye. Member Wong.
Aye.
Member Wong, aye. Member Wolf, absent. Moved by Chair LaHood, seconded by Member Wong to table the matter per complaint procedure 7B without prejudice and inform the parties that they have 60 days to request that the matter be opened.
Thank you. And Cheryl, I want to make sure, is your microphone picking all of that up?
Is this?
Okay. It was.
I think.
Okay.
This is Victor. I did hear everything.
I'm sorry, say that again?
This is Victor. I did hear it all.
Okay, great.
All right, next item.
Next item, please.
Item number 10, committee members will review Articles 1 and 2 of the Sunshine Ordinance and discuss possible amendments to recommend to the full task force. Recommendations proposed by members of the public at previous committee meetings will be taken into consideration. Discussion and proposed action to forward recommendations to the full task force. And we have 2 links for documents that were part of this agenda.
Okay. And one thing that I'd like to say before we get started here is that we're expecting that this process will take several meetings, which is why we only put Articles 1 and 2 on this agenda. And I want to make sure that there's, time for robust conversation. I wish that actually we might be close to getting Member Wolf back in for the discussion. Here's what I'm thinking. Since we do have a few members of the public who are here with us, I'm thinking that I will give I'll give members of the public 3 minutes each if they want to say something at the beginning, and then Member Wong and I and Member Wolf, hopefully when he arrives, I think should start going through this sort of section by section, maybe doing a couple of chunks at a time, and we will give further opportunity for members of the public to respond section by section. So in your opening 3 minutes, don't feel as though you have to say everything, because you will have another chance to comment on discrete points within the Sunshine Ordinance text. So I do see someone at the podium right now. And Victor, if we could, after we have our in-person speaker speak for 3 minutes, if we could start a queue for those online, and we'll give everybody 3 minutes this time around. And then we'll have a few opportunities in the middle.
Just so you know, I have made everyone a participant now, and they all have controls over their own microphones. We have 2 guests with us online. We have Mr. Pilpel and we have Maxine.
Okay, great. I'm going to let our in-person guest introduce herself, and Ms. Lachey, please let her know when you're ready with the timer.
How many minutes?
3 minutes each.
3 minutes.
Yeah.
Okay. Are you ready?
I'm ready. Yes.
Okay, great. Go ahead, ma'am.
I'm Allison Washburn, a former member of the task force and of this committee. Currently the chair of the steering committee of San Franciscans for Sunshine, which comprises primarily past and current members of the task force and members of the League of Women Voters. The League has been supporting the Sunshine Ordinance from its inception and is very much involved with efforts to update and strengthen it. The 2 documents that were uploaded, the first is actually the text, the original text of Articles 1 and 2 of the Sunshine Ordinance, along with changes that began actually in this committee I would say almost 20 years ago. And in the interim, additional amendments have been proposed by San Franciscans for Sunshine and other people. This has been an earlier version of this was vetted by the city attorney's office. The second document, which is a detailed description of the changes, a lot of that language is from the city attorney's office. Although since that review, which was done in 2016, there have been additional changes made. So when I spoke several months ago about what we have in mind, it was, is it possible to move forward with some of the amendments through the task force, taking this to the Board of Supervisors? We're thinking of things like amendments to correct original drafting errors, amendments that clear up some ambiguities, like substituting 3 business days for 72 hours, which always confuses people. And then some other needed and possibly non-controversial amendments. The one that comes to mind is staggering terms for members of the task force. That's, of course, in Article 4. But just briefly, I wanted to say that members of San Franciscans for Sunshine believe that what is really needed is for the task force to become a commission, and that there be a charter amendment to that effect, which will be very parallel to what we see for the Ethics Commission.
Thank you. Thank you for your comments. Mr. Young, who is next in line? I'm not hearing anything. Mr. Young?
Victor?
He's muted currently.
Sorry about that. I keep forgetting. So we have 2 other people with us today. I gave them control over their own mics. We have Mr. Pelpel, but they have not raised their hands or indicated they want to speak yet. Mr. Pelpel may be otherwise disposed, but Maxine, would you like to make comment at this time?
Ms. Anderson, if you'd like 3 minutes, we would invite your comments.
Thank you very much. First of all, thank you for all the work you're doing with this committee and with the Sunshine Ordinance Task Force. My name is Maxine Anderson. I'm a member of the League of Women Voters of San Francisco. And as Allison has stated, the League is very and has always been very interested and advocates for open government. The Sunshine Ordinance gives us that opportunity here in San Francisco. We have right now an ordinance that was crafted during a time when we didn't have the sorts of technical advances we have now. And so in order to bring it up to the 21st century, we need to look at ways that we can update it to make sure that we take into account all the different ways that people now communicate. We don't send as many faxes anymore. We have Instagrams, we have technical advances where you can delete a message or have it disappear. With an open government, we need to make sure we capture all the information we need for the people to be informed of what their government is doing. A couple of things as a part of this and looking into redrafting or just updating the ordinance that we had identified was that we need to have a central location where all the meetings are and the scheduling for all the meetings and their agendas is located. And it can and should be right in one spot on the city's website. So you shouldn't have to go from one department to another department to find out what's going on. It should just be one major calendar that you all could feed in from, that departments can feed into to let people know when the hearings are being held. And also for passive bodies that we have in the city, that those hearing schedules should be posted not only on the city's website, but also in the main library so people can find them. So we'll know when there are any passive bodies having hearings. So I don't want to take up too much of your time. I'm interested in hearing how you all want to put this together or line up how these issues could be addressed. So that's the end of my comments. Thank you very much for taking my comments.
Thank you. Thank you. Thank you both. Do we have, does Mr. Pilpel, would Mr. Pilpel like 3 minutes?
I believe he does. I saw his hand go up and down. Oh, here goes. Maybe he recalled in.
I did call in. Can you hear me better on the phone?
Yes.
Yes.
Great. Fantastic. Okay. So I assume that you're on item 10.
Hold on.
Sorry.
I
Ms.
will
Leger
hold.
will let you know when she's ready with the timer. Thank you.
Okay.
Thank you, Dave. Okay. Are you ready to begin?
I am.
You may begin.
Okay. So I assume that you're on item 10. I checked in a few minutes ago. You were on item 9. I thought that was going to be a while, so I went and did something else. So I'm back. And on item 10, I heard most of Maxine's comments just now. I did not hear, is that Allison that's in the room?
Yes.
Hello. Greetings. Nice to see you from the back right side. Anyway, I agree with much of what I heard Maxine say. I'm sorry I missed the introduction and Allison's comments. I do hope that there, as I've said before, I hope there is a fair amount of agreement on positive changes that can be made here as to Article 1. I think one could do a quick set of edits. I think Article 1 just really states kind of, universal thoughts and doesn't compel anyone to do anything specific, but it's nice flowery language and it could always be updated. As to Article 2 and meetings, I think that it still makes sense to have lesser requirements for passive meetings because they're really something more like staff meetings or certain things that are like somewhere between a staff meeting and a decision-making body. And I think the kinds of requirements that are there for passive meetings still make sense in the main. I am more interested in the difference that still exists with regard to charter, board, and commission meetings and other policy bodies in Article 2, particularly those that are set up in the administrative code and other city codes. And I see less of a reason, if any, to have distinctions between those types of bodies. Whatever the agenda requirements and minute requirements and public comment and all of that should apply equally across the board. And so there are some particular provisions, for example, around minutes that apply to charter boards and commissions and do not apply to other policy bodies. I also wanted to point out a couple of instances where there are good practices that exist now with regard to some bodies but don't apply universally. For example, the Board of Supervisors publishes draft minutes of full board meetings by one day after a board meeting. Board meetings are usually on Tuesday. By Wednesday, 5 o'clock, there are draft minutes available. So one can find out what the actions were, and the Board of Soups even already has, who made public comment and what the disposition of all kinds of things are. So there's a lot of detail there. The Ethics Commission posts a 1 or 2 page summary of actions that in narrative form explains. Am I almost out of time?
Yeah, actually, you are out of time, but just to let you know, we will be giving other opportunities for public comment throughout.
I'm happy to share other thoughts. I'm right here.
Okay.
Thanks.
So I also want to make sure, I know Bruce said he might be coming back. Has he returned to the meeting or not yet? Okay, not yet. Here's what I'd like to do. I'm going to start, I'm going to talk first with Member Wong, and then we will open up for public comment on various sections. I am thinking, and Member Wong, why don't you tell me if you In terms of chunking this out, I think we could very easily do 67.1, 67.2. We could take comments on that, or we could also wrap in 67.3 and then take comments on all three of those sections. Do you have thoughts or a preference?
I don't. No.
Let's do all three. Oh, and don't worry, I will give plenty of time for comments. Because I know 3 is quite long and there's a lot in there, and I don't expect that we are going to get. Again, this is going to take several sessions, but I think as we work through this, we can figure out what are the easy pieces and where there might be more debate and discussion. Member Wong, do you have anything specific that you'd like to note in section 67.1?
I don't. I don't know that I am prepared in the right way. I don't think I knew how exactly this discussion was going to go. So
okay. I think we had a discussion about it a couple of months ago. So I understand that. And then because we had to postpone last time, it might not be as fresh. One thing I would like to address, and I believe Ms. Washburn said the changing of the task force to a commission, right. Which is and a very interesting idea that I know has been raised before. And I know linguistically that would require a lot of changes throughout. But in some ways that feels like a discussion that maybe is beyond what I think we can accomplish in this series of hearings, although absolutely that's something that should be discussed at the full task force level. So I do want to track that, but I don't know. And if anyone wants to comment further on that, I invite that, but I don't know how much time we would necessarily need to spend debating the merits of that here. I also did not have much in the first section, but again, when we take public comment, if there are specific things that people want to note, that would be fine. Also, Ms. Washburn, you had referred to some documents that you sent. I don't believe those came in time to be attached to the agenda, but Ms. Leger, if you could attach them for this discussion section for the next agenda. Again, this is a rolling discussion, I would like to have those attached and identified as having been sent by Ms. Washburn. And if anyone else either participating now or who hears this later and has ideas that they want to submit, if you have any recommendations that you would like to attach to the next agenda, we do invite those so that everyone can see them as we discuss them. Moving on to 67.2. I don't think there's anything to change there. I'm just going to keep going, but if anyone, again, has comments on that, of course, we can come back to it. If we move on to 67.3 with definitions, and maybe if we look, let's start with everything through B. One thing that jumps out at me is this idea of a majority of members of the policy body at the same time and place, especially given what happened with the pandemic and the discussion of what does place mean. I mean, we are all meeting at the same time, but we are not in the same place. And I don't know how, I feel like there might need to be some modification in there about what is allowed in terms of virtual participation or by phone. And would love to have us discuss that. Member Wong, is there anything that jumped out at you through items A, small a and B?
No, again, my understanding for this this agenda item was to look over suggested amendments from the public and comment on those. So I do not have my own suggestions or comments prepared at all. at this
Okay.
time, unfortunately.
Okay.
I think part of the issue is that I was not present for the first meeting when this was placed onto the agenda. And so I don't think I had full context of what was being planned.
I see. Well, that's okay. This is going to take several meetings anyway. Maybe then here's what I will do. I will run through a couple of other things that I saw in section 67.3, and then I'm going to open it back up to members of the public to offer their comments, which I think will help us in terms of building a public record. It'll be great to have this audio, and then we can go back and sort of condense and refer to the suggestions that are being made regarding each of the sections.
Chair LaHood, could I also make a suggestion?
Mm-hmm.
Where when we continue to hear this item, I think it would make a lot of sense for us to prepare specific sections for each of our hearings. I mean, probably based on how tonight's goes and how long each of the items take. But I think that would help not just myself, but probably the members of the public as well, so they can be prepared to comment on specific sections.
Absolutely. We do have on the agenda that this is about reviewing Articles 1 and 2. Perhaps it is overly ambitious because Article 1 was so short and it seemed like, well, then we'll just add on Article 2, but Article 2 is quite extensive. So I think you're right that perhaps we could even spell out in more detail which pieces we're looking at, and maybe don't need to take it article by article, but we could break down to even further subsections and have more robust conversations on each one. So that is a good suggestion. Other things that had jumped out at me, and I know there was people have comments about clarifying what passive meeting bodies are. I'd also like us to consider, we've had in the past few years a couple of complaints come before us regarding like green, I think it was community business districts, green district formation committees, which raised a lot of questions and concerns because these were not city bodies, but yet there was city participation, and I think in some cases even city funding being directed to these groups. And there was questions about how did the Sunshine Ordinance apply to these? Again, not a conversation I think we can resolve in an evening, but I think something to add to the list of what we should be discussing. And I'm going to open it up again for public comment on anything through section 67.3. And I will say, since it's only 8:45 and we have 3 participants, we can give everyone 3 minutes again, but you don't have to use your full time. I know some of you will have more comments on some sections than others. And unless there's opposition, I'm thinking let's just go in the same order in terms of efficiency. So Ms. Leger, whenever you're ready with the timer, we'll let Ms. Washburn speak first.
Are you ready, ma'am?
I'm ready, yes.
Go ahead.
Okay, I just wanted to make a pitch for the Sunshine Commission language, and this is a big deal and does warrant further discussion, certainly. But I actually just looked up task force in the dictionary, and it really means something that's rather short-lived and has a specific purpose. That's the common sense of it, and certainly that made sense early on. But this appears to be a permanent body, so changing its name makes sense. I have some questions. 67.3B1 about what a meeting means, a congregation of a majority of the members of the policy body at the same time and place. And our group has thought about this in light of COVID and also in light of the attempt to claw back, for example, members of the public having to be at a meeting in person, and unless they, had some reason why they couldn't because of a disability, for example. But I think our group is thinking that for as much as possible for public meetings that the members of the body should be present. So, and we may speak to that later on. I actually didn't go back and study this in detail for tonight. I was, but that's something that warrants further discussion. I agree. I wanted a clarification, Chair LaHood, about these entities that have sprung up recently, certainly since my tenure on this body. What are they called? These business?
Like one that came before us, there was was it a Green Business District Formation?
Right.
Formation Committee. So it wasn't
the reason.
What?
The only reason it came to us was because Mr. Sullivan felt he had a right to videotape the meetings.
Right.
And the group said, no, you can't.
Because the group said they were volunteers.
They were
it wasn't a body, and that even though it was a formation committee, the body hadn't been formed. And it was a very interesting discussion, and I think we need to take situations like that into consideration and see if, how is the line where it should be, or does the line need to be moved a little bit to include groups like that if they are working with the city?
Right. I know there's a distinction.
Also, the other stipulation is that those who are within the group all agreed to do it.
Right.
And that was the big problem with this particular Green Benefits District Committee. They were neighbors, and they weren't necessarily looking to do something that would involve commitment from the city. This was like exploring what was
right.
going.
So it was interesting. It's not clear cut, but I think that's something that should be considered.
Right.
Yeah.
We were trying to clarify what passive meeting body means. That's the goal.
Yeah.
So I think this is a chance to really try to be as clear as possible, knowing that new bodies types of bodies are going to spring up. I mean, we're saying that all the time.
So I believe we ran through your 3 minutes.
Sorry.
But
we took your time.
I was going to say, give her another minute, because when you asked a question, we jumped in.
All right. I will adjust the time.
I just wanted to say that the work done on this particular part, the effort was here in particular to, as I said, for once and for all, to be clear about what a passive meeting is and what do we, what is the responsibility of those at the meeting to be as transparent as possible and as available to the public as possible. So, for example, we don't say that they must allow public comment. For example, they can, but they don't have to. Should notice the meeting, at the agenda and so forth. But it does differ. But what constitutes a passive meeting body? But I think when you read further the policy body, I think we've nailed that down more firmly than as David Pilpel was suggesting. So.
Okay, thank you. Ms. Anderson, would you like 3 minutes to speak on the everything through 67.3?
Thank you very much. Basically, I'd just like to say that I concur with what Allison has said. And I also concur with what you said earlier, where we try to break this down. I didn't know exactly how this was going to be handled. And I just looked at it in terms of the listing that you had attached to the agenda. So I just thought we were going to go through those issues and maybe strike out some and highlight others. But now that I'm getting a better sense of this, that we're going to go through it systematically. Again, we do need to have definitions so the public knows what a passive body is and what they should be able to expect in terms of having transparency within those bodies. Again, the League of Women Voters is, we believe in open government and transparency and people understanding how their government works. So having definitions that the public can readily put their hands on is very important to us. And with that, I'll hold the rest of my comments as I listen to more of what's being said here. Thank you.
Thank you. We'll let Mr. Pilpel go. And I'm thinking, since maybe we can go through a few more sections, we can also go through that list that we added. I wanted to append that because we did some sort of general intake of ideas before, and I wanted to make sure that we weren't losing those. We can discuss those at this meeting or at a future meeting. Since there's so few of us, we can maybe we can decide as we go. Mr. Pilpel, do you have any specific comments on everything through section 67.3?
Member Wood, before we start on that?
Yes. Is Member Wolf back?
I was just going to say, I'm seeing his face. So, Member
Okay.
Wolf, there's a smile. He's here.
Okay. Member Wolf, we are, you'll catch up. I'm not worried. Mr. Pilpel, if you would like 3 minutes for any comments specific to section 67.1, 67.2, or 67.3, you've got 3 minutes.
Can you hear me now?
Yes.
Okay, great. So yes, I do. So back to 67.1, it may not surprise the members that I've been thinking about this for a long time. I, in fact, have kept a document since 2005, which I'm looking at, which is now going on 18 years, of edits that I thought of at that time. I've made the occasional change since then, but it's largely still the same document from 18 years ago, and a lot of those edits still make sense now. So for 67.1, I just have a long series of technical edits that I think ultimately pulls out a few words and makes it more consistent throughout. I'm happy to submit those. It intends to change nothing of substance in 67.1, but just makes it read a bit better. As to 67.2, I would agree with Allison that the question of whether, well, I mean, I think the ordinance will still be known as the ordinance, and I'm fine with that. Whether the body is known as a task force, a commission, you know, some other entity, I think is a good debate and discussion. I would suggest putting that off until the discussion on 67.30 as to the members and more on the legal landscape of how this may come about. If it's a charter amendment, that would and putting all kinds of language in the charter, that would suggest more a commission. If not, then there are other potential names. But I'm not like hung up on the name of the thing right now. I'm more concerned with the substance. So that's 67.1 and 2. As to 67.3b1, I agree with Member LaHood that there is a kind of a problem with at the same time and place, given how things are currently happening. I also had language to add to that to make it be more consistent with 2, but perhaps just dropping the 2 words and place, so at the same time. And then the language that I added to make it consistent with 2 is at the same time to hear, discuss, or deliberate upon any item within the subject matter jurisdiction of the policy body. So it's not just that a majority of the members are getting together at the same time, not necessarily the same place, but it's for what purpose? It's to hear, discuss, or deliberate upon any item within the subject matter jurisdiction. So if you happen to find yourself together at a social event or in an elevator or whatever, so long as you're not hearing, discussing, or deliberating upon any thing within the subject matter jurisdiction, I don't consider that to be a meeting, and I don't think a reasonable read of the law should reach that conclusion. So that's 67.3 B1. If I just have another couple of seconds, I think the question of scope and which bodies are covered is a good discussion either now or in the context of 67.32, because there really was some thought about what was within government and covered or potentially covered and what's outside government and thus not.
Okay.
And have
Mr. Pilpel,
is that enough
I'm
for the
gonna
moment?
cut you off there. I wanted to let you finish your thought, but I
Okay,
want to make
I'll
sure
leave it
we're
at that for the
consistent.
moment. Thanks.
Okay. Okay. Member Wolf, welcome. What we're doing, and as I said from the beginning, this is going to be a multi-meeting process, and I thought a way to get in this was go section by section. We have 3 members of the public who I've been inviting to make comment, sort of give additional public comment as we go through some of the sections. Member Wong, I realized wasn't there at the initial meeting where we were discussing how this would work, and there was a little bit confusion, especially since I had attached sort of the summary of suggestions that had come in from our previous discussions. If you are amenable to this, I would like to continue through a few more sections where the members can discuss our thoughts on changes, and then we'll open it up again for public comments. I know it may seem like things are moving quickly, but again, this is not definitive. This is just an opportunity to capture these ideas. And at some point, we will post our version of a draft with suggested edits that we then can get additional comments on. If there's interest in going through the attached document that it looks like it was item 8 from a previous meeting, we can definitely go through there and get comments on that. But Member Wolf, any thoughts on this before we proceed?
You mean as far as process?
Yes.
No, I think it's okay. We've got to start somewhere, and I guess it'll evolve, into where and how it's got to go. I do think going through it, section by section. I mean, I think going through it section by section will be helpful. We'll get, I think, a lot more robust discussion out of it. I'm just also want to be cognizant of time.
Mm-hmm.
I mean, if we're looking at a 2024 ballot, we want to make sure that we can get through it within a year. So, because then we have, once it comes out of this committee, then we have the task force to contend with.
Exactly. And we know there will be another layer of debate required at that point. So right. I hear you.
I'm wondering if it wouldn't be amenable, including our guests today, if and when we get through a certain section, if we can get to maybe some consensus or not, and then move those sections forward to the task force. So it's kind of done in piecemeal versus all at once.
The only reason I would advise against that is because I think within the ordinance, there are some references from sections to sections. And I would rather have a less polished but complete draft to send to the task force, like moving through it faster to get all the way to the end.
Okay.
rather than, although maybe if it's at least complete articles, maybe that could work.
Mhm.
Let's think about that.
Yeah, I mean, yeah, Article 2 and Article 3 are distinct from each other. They
Yeah.
don't, they
That
don't
could
reference each other, you know.
Right. That could work.
Yeah.
Okay.
All right. Well, that sounds, I mean, place to start.
So members, let's look at 67.4. And again, I know, member Juan, your head is probably spinning. I will say that one thing that jumped out with me is what Ms. Anderson referred to in regarding the city needing a central calendar. And, you know, when I look at 67.4A1, you know, such gatherings need not be formally noticed except on the city's website whenever possible. I think this might be a good place to add something about having a central calendar, you know, and that does not preclude also having those items on each department's calendar, but having one place where people can look up and see what is happening in terms of city meetings on Monday afternoon. And, you know, being able to search and sort in all the ways that we know are technologically possible at this time. Members, does anything else jump out at you in terms of 67.4?
So I'll jump in. I would say in relation to what you were just mentioning, that there be, and I don't know if this is too far down into the details, but to also make it available for the public to be able to sign up for noticing.
Mm-hmm.
And I don't know if that needs to be codified or not, but to make it, you know, a requirement, you know, for noticing, that there could be some sort of self sign up. The problem with that is then it's accessibility at the same time. So, you know, it has to be accessible. You have to leave it open for people to use the most default, which is a phone call. Please sign me up.
I think that's a good addition. I'm going to, and don't worry, we will take public comment, but I'm going to add a few more things. 67.5. I mean, this refers to the Brown Act. I don't know if there's anything to be edited here, but I want to open it up. Members, any comments on this section?
The only thing, I think the code section changed, didn't it?
Yes, but the good news is we heard from our deputy city attorney that although it's not happening immediately, there's a process for cleaning up all of those code changes, so they eventually will be replaced with the correct numbers. If we trust the system to work.
Yeah, I mean, this is somewhat, consistent with the Brown Act anyway.
Mm-hmm.
You know, in creating greater or expedited public access. That's already there.
Okay, and if we jump to 67.6, I have a few thoughts on this, but members, I'll say them first, and then I think this section, again, time and place for meetings, I think we need some clarity about, what constitutes place and what language we might need to incorporate about virtual access. Acknowledging what Ms. Washburn said, that ideally, members of the bodies as much as possible would be here in person, but also recognizing that there are some allowed exceptions but also knowing that more and more members of the public seem to be participating remotely, and what might be required to facilitate that more easily. Also noting the section on emergency, which in the past couple of years I think has been, boy, was that put to the test. I'm also wondering about in section F, talking about waiver may be given by telegram, which seems so archaic to me, arcane at this point. And then talking about further provided that the notice of the special meeting shall be given at least 15 days prior to said special meeting being held at an alternate location. And it just seems that, you know, with modes of communication available to us at this point, do we still need 15 days for that kind of noticing? Those are things that jumped out at me. Member Wong, Member Wolf, is there anything else that you've noted in this section or that you would raise? Again, this does not have to be everything under the sun. I'm just thinking if we can go through a little bit and then get some comments maybe on those past couple of sections before we move forward.
I'm just quickly reading through.
Mm-hmm.
I think what Maxine had mentioned earlier about facsimile, that's also mentioned in section E. Something else that may be worth being more specific about too is in section C regarding holidays. I don't know if that should be a little more specific or it should continue to be loose like that, or even maybe more generic. As holidays continue to change, and I don't know if it's like, is it a state holiday? Is it a city holiday? Is it a holiday recognized by a member of the body? I think that, I don't know, could use more detail potentially.
Good idea.
Actually, there was one other thing I just was able to open my notes for 67.4, but it also applies to agendas in other places, is just the 3 business day
right
notice of agendas. You know, my concern, and I'll just say it now, so when we get to that part, you'll have heard it here now. My concern is that when we look, there's just so many items on agendas now and commissions at the Board of Supervisors and the enterprise agencies that are they're like so pertinent to everyday living. I mean, really serious stuff that will change like the landscape of the city in a way and the way we operate here. That 3 days is not enough for the public when those departments and those commissioners have been looking at all that work product for months, if not years. You know, that the public gets to see it for the first time 3 days before the meeting and is expected to, have read through, hundreds of pages or very arcane legalese or constitutional language, that can be very complicated and not knowing what or have the time. So I want, just as a rubric, I want us to think about whether 3 business days for agendas is still appropriate, and if maybe it should be longer, more days in advance. And maybe for certain bodies, it's a certain amount of time. For other bodies, it's a different amount of time, that kind of thing.
Thank you. That is an interesting comment, and I'm seeing that coming up in at the top of the next section as well. But before we get there, I would like to give our opportunity for public comment on 67.4, 67.5, and 67.6. Again, we'll give you each 3 minutes, which you don't need to use if you want to keep things moving until we get to a later section where you may have more passionate comments.
Wait, yeah, it's right here, 676. So yeah, it applies right now.
Okay. Okay. And I'm just going to keep going in the same order. So Ms. Washburn, if you would like to comment, Ms. Leger will let you know when she's ready with the timer. And just so everyone knows, the first timer tells the first ding gives you 30 seconds left. The second ding is the end of your time.
Okay,
Ready?
I'm ready.
Okay. You may begin.
Okay, so 67.4 B, I know Maxine was emphasizing the need to have information about meetings in one place. And I had forgotten that we had this for passive meeting bodies. And I think we should make sure that we really nail this down. We want to make it very easy for members of the public to find out what's going on. I like Bruce's idea about having members of the public sign up for noticing. So efforts like that, I think this is an opportunity to really get serious about that. And 67.6, time and place for meetings. Yeah, this is something that we know, the group of us that have been in the trenches on this know that we need more language that will clarify this for everyone, for members of bodies and members of the public. Yeah, we need to get facsimile out of this. But in defense of the drafters here, we did get Telegram removed because I don't think telegrams are a thing anymore, right? I don't think you can, Western Union's out of business. So I checked and it had been stricken. So, and the 3 business days, Bruce makes an excellent point. Again, this is something that he's just, we're just thinking about right now. And it's in line with this principle of really making it possible for people to know what's going on, to have an opportunity to participate. But the 3 business days, I think there was 72 hours throughout the whole ordinance. And I think we just kind of defaulted to 3 business days, and we need to make sure we tailor the length of time. It should be in business days rather than hours for sure. But, really think carefully about this principle of making it possible for people to be active participants in their government. And I have to say that I'm fading, folks. I'm starting to lose my voice, which is, I haven't done that much talking today.
Okay, thank you. Ms. Leger, if you want to reset the clock, and Ms. Anderson, you'll have 3 minutes. And again, we're focusing on 67.4 through 67.6.
Are you ready, ma'am?
Yes, I am. And I'm going to be very brief because I am agreeing with all the points being made by both Bruce Wolf, although I had not thought about extending the notice time on the agenda from three business days to maybe a week out, so people have an opportunity to digest the information that's on the agendas. But that is something definitely worth thinking about. But other than that, I believe I have stated for purposes of these sections what I felt about what possible changes could be made. So with that, I will cede the rest of my time. Thank you.
Thank you. Ms. Leger, if you could reset the clock, and Mr. Pilpel, you've got up to 3 minutes for 67.4 through 67.6.
I'll try. Okay. I definitely agree with Maxine on the master calendar. I'm not sure. I tend to think that the best place for that is somewhere in 67.29-2 about what needs to be on the internet, but I'm open to other ways to do it. I think it should include passive meetings, policy body meetings, other kinds of events. So yeah, you should be able to say, hey, it's a Tuesday night. What's happening? What are my choices if I want to engage with government? Passive meetings, 67.4B has always been a bit of an odd section, and I would want to revisit that in the context of 12L and nonprofits. I think that there was some intent behind that section originally. I'm not sure if it still makes sense or if it needs some tweaking. I'm not sure how workable it is. 67.5 is really just incorporating the Brown Act. I don't believe it was the Brown Act that was renumbered. I think it was CPRA. So I think the current Brown Act references are generally good. On 67.6, there's a lot of work that could be done there. I would suggest that that's probably a larger discussion for another night or day about what are ongoing responsibilities of departments and policy bodies about having procedures in place and setting regular meeting times and such, and then what are the more specific requirements throughout this article that should happen before a meeting, during a meeting, and after a meeting. And those can be segmented, and there's a lot to all of those concepts. I agree that 3 days or 3 business days in many cases is not sufficient time. I think that it is generally sufficient only for bodies that meet once a week and have a quick turnaround. For those, I've always believed in a 3-5-7 scheme. So those bodies that meet once a week, 3 days in my view is sufficient. Those that meet about twice a month, 5 business days or 5 calendar days, something like that seems more appropriate. And for those that meet once a month or don't have a regular schedule and meet on call, I think 7 days or a week out makes sense. Principally, as Bruce mentioned, so that things that are, brand new big ideas for reshaping the city should get more time and attention rather than just 3 days when you put something out on a Thursday or Friday for a meeting on Monday, and you're going to, re-examine the whole world at a Monday meeting. That does not seem cool. I'll leave it at that for the moment. Or next time.
Thank you. So let me ask members Wolf and Wong, would you like to go through a few more sections, or would you like to review the suggestions that we had received and consolidated from previous meetings? What are your thoughts?
Member Wolf here.
Yes.
Well, I think it's worthwhile if we received some items from previous meetings that we should at least see if any of them match up now or not. Or if not, then we'll just, forge ahead as we have been. But I don't want to dismiss anybody's good work and good thoughts, whether they're acceptable or not.
Okay. The one interesting thing to note on this, and I believe someone said this early in the meeting, is some of these suggestions are even at odds with each other. But perhaps it would be good to go through. Actually, maybe we could look specifically the ones that pertain to public access to meetings. We have a lot of recommendations regarding public records, a few recommendations on the list regarding public meetings, and then a longer list regarding implementation, operations, and authority. Do you think we should just look at the public meeting ones for now, or just go through the whole list and sort of see where we have either agreement or disagreement?
No, let's just look at the ones that pertain to what we're talking about.
Okay. So, and we haven't gotten to all of these things yet because we have not gotten to the end of Article 2. But I'll just read these into the record. The previous comments that or suggestions that we've received regarding public meetings from those earlier sessions were require all boards and commissions subject to the Sunshine Ordinance to keep minutes. And I think someone else had mentioned something related to that earlier. The second one is provide consistent requirements for all public meetings regarding agendas, minutes, and the conduct of meetings. The third is create a centralized website documenting all upcoming city meetings and agendas. We keep hearing this. Everybody wants this. And I think if there's anything we really fight for, I think that would be I think that would be the most appreciated. And then require agenda items to include a proposed action or be identified as for discussion only. I know where that came from. So, I'll ask members first. Any thoughts on these? Do any of these yay, nay, or requiring discussion?
Go ahead, Member Jamal. I keep going first. Do you want to go first?
Oh, no, that's okay. Yeah, you missed it. I earlier had said I don't think correctly prepared for this item. So.
Okay. So I would say, just looking at this, that there's more types of meeting bodies than just boards and commissions.
Mm-hmm.
You know, and so I think we need to. It's got to be like the compendium of meeting bodies versus trying to identify. Somebody will think of a new animal in the future, and we have to find a way to kind of encapsulate that. I mean, the framers did the best they could to try and cover things up to now, 20 years later, and it's been okay. So I think we need to follow in the same kind of thought to try and be, somewhat all-encompassing. And a board and a commission and a task force and whatever, animal it is.
Do you want them all to keep minutes?
Yes, they should all keep minutes, including passive meeting bodies.
Okay. Any thoughts on any of the other ones on this list?
I think everybody's already mentioned that, centralized area on the web for meetings and agendas. Consistent requirements. It's really a matter of like format, right? That there's some like agreed baseline standard. Because if you ever review the ethics commission, let's say, their agendas are called interested persons notices, I think, or something like that. I don't understand what that means with regards to an agenda, that kind of thing. So I think, an agenda is an agenda. Call it an agenda. Everybody needs to call it an agenda. I think we have to get to a place of where things are familiar and predictable. In a decentralized, very siloed government, things need to be, for the general public, predictable and familiar.
Okay.
I'll stop there.
Okay, Member Wong, any other thoughts on these 1, 2, 3, 4 suggestions?
Not at this time, no.
Okay, I'm gonna open up for public comment. And do you all have, I know I read it into the record, but I hope you all have visibility. Again, this is from the attachment that was labeled in item 10, but labeled item 8. And about halfway down, there's a short section with the recommendations regarding public meetings. So Ms. Leger, if you want to set the timer, and you don't need to use the whole 3 minutes, but or set it for 3 minutes, and we'll start with Ms. Washburn.
Are you ready, ma'am?
I am. I don't know that I have a whole lot to say about the suggestions. I know that one thing we attempted to do that might be relevant here is to be under policy body, we expanded what that means. So it's, it's not just commissions that are mentioned in the charter, for example. And that this is actually under definition. So a lot of what we're requiring later on in terms of agendas, the way meetings are conducted and so forth applies to, really uniformly across those bodies. So maybe we, in a sense, have addressed that problem already by our most recent language, if I'm understanding what that particular suggestion was. So I think that, it will require that we go back and really, for me at least, review the definitions again, make sure that we've brought all the animals that we can into their right cages, knowing that there are new ones out there, these green business district committee or whatever, these exciting new exotic things. Green Business Foundation.
I think it's Green Business District or Green Benefits District. Sorry.
Green Benefits District. Okay.
Yeah.
All right. So I think we may have done that, but we need to go back and make sure. And then once we're expansive enough with the definitions, it may make everything else easier to do. And I'm not sure what I think about having all meetings run. I mean, there could be best practices. That would be a project to come up with best practices. I don't know if that needs to be in the ordinance or not, or whether we expect all of these bodies to operate in the same way while adhering. I mean, they would have to adhere to the ordinance as far as agendas and public comment and all that stuff.
Okay, thank you. Ms. Leger, if you'd like to reset the timer, and Ms. Anderson, we'll give you 3 minutes to comment on these suggestions and comments on them that you've heard already.
You ready, ma'am?
Yeah, thank you very much. As far as the suggestions, I think they're pretty much encapsulated in what we've been speaking about before we went to this particular list, because what we're talking about here is establishing some consistencies, hopefully, in as far as our different boards, commissions, policy bodies, anybody working on the business of the city, with a long definition of that to me. To have some consistency in what they present, because otherwise the public will be confused as to what it is they should expect. And I think it makes it easier if there's some consistency. They don't have to be totally conforming, but at least some kind of framework within which our policy bodies can work. If you use my definition for policy bodies. And other than that, we've spoken about the centralized website location for meeting schedules and agendas. And let's see, the other thing they said was, I don't exactly know what they mean by require agenda items to include a proposed action or be identified as for discussion only. Do they basically, is the suggestion, if you understand this, that if there's going to be something the body is going to do, that it should boldly say that, or if it's just something people are talking about, that should also be said also. So I need more clarity on exactly what was meant by that suggestion, since both things could be going on in any one meeting. So with that, I am done. Thank you.
So before I hand it to Mr. Pilpel, I will answer that question. That particular point comes from a member of the public who, so there is language like this in the ordinance. With regards to the Sunshine Ordinance Task Force, he has been asking us to put on the agenda that our action is to find a violation. And since we haven't had our hearing yet, it doesn't seem to make sense for our procedures. And it may be getting too much in the weeds for that. I understand what he's asking for in wanting enough information to know what's going to happen at meetings. But it's a very fine point. I don't know if Member Wolf or Member Wong, you have thoughts on a better way to describe that particular recommendation.
Well, the way I've heard it was everything that's on the agenda is actionable, whether it's for discussion or not. And I don't ascribe to that. I don't agree with it. I understand why a person might think that. And in some meeting bodies, not government necessarily, that could be the case. Any item that's on the agenda could go from discussion to action, but their bylaws would have to allow for that. I think in government it's a completely different thing, and that there has to be a lot more deference to the public than there is to the body itself. So if the body wants to say that it's for discussion only, then it's discussion only and no action, will be taken. Period.
So thank you. Mr. Pilpel, we'll give you 3 minutes, Ms. Leger, when you're ready with the timer.
You ready, David?
I am.
Go ahead.
Okay, so on a variety of topics here. First, on passive meetings, I think if you require minutes and too much process for passive meeting bodies, they'll just stop creating them. And instead of having, some smart people in a room talking about something as a passive meeting, you'll just get, some unnamed, unknown staff person in the mayor's office creating policy, and suddenly that'll be the case, and we'll have no idea how it came to be, and there just won't be passive meetings. And it's not about this mayor, it's about any mayor, and it's just the way the bureaucracy works. So I think it's important to have some process, but not too much around passive meetings, understanding that that's not the last stop for decisions on that issue. I want to go back for a second, and we should have a broader conversation sometime about what is a meeting. I think it really is a gathering of people at the same time, not necessarily the same place, but on the same topic. In this case, a government-sanctioned body, not a private entity, that's
one of several things. It's either a final decision-making body that's an advisory body like Prozac or the MTA or PUC, CAC, an advisory body, or something that's lower level like a passive meeting body. And I think you continue to exclude staff meetings because staff are going to meet all day, every day, and keep notes or not keep notes, and that's going to be whatever that is. So that leads me to the point about benefits and burdens. I think where there's a meaningful and demonstrable public benefit, even if that imposes additional burdens on the government, then those costs should be ascertained, and we make trade-offs and say, okay, I am willing to pay for minutes for all bodies or certain bodies, or I am willing to have 3 minutes minimum of public comment for any person who shows up on any item, blah, blah, blah. But there are trade-offs for all of that, and those costs are not, in some cases, insignificant. So I think we should bear that in mind. Last 2 points here. The dynamics and needs really do vary somewhat by body. Those bodies that are concerned with land use or are case-driven are different from those that deal primarily with policy and contracts and legislation. And so understanding that the nature of the Planning Commission is different from the Board of Supervisors and the MTA Board and the PUC and Rec Park is useful. And finally, on this question of the contemplated scope of an item and the intended action, where there really is a clear intention, I think that should be stated, as opposed to we've got a case involving 1234 Market Street and that's open for action and discussion. You can't predict in advance where that's going to go. And so having some flexibility, I think, makes sense, but where there really is a staff recommendation or an intended action, that should be specified on the agenda. I think we're in agreement there. Thanks.
Okay, thank you.
I have to run.
Okay, Ms. Washburn has to run. And members, I want to ask you, I know we had some petitioners not show up today, and so we were able to start this discussion earlier, which was fortunate because there's a lot to be said. Would you like to continue, or would you like to wrap up the meeting and continue this at our next Compliance and Amendments Committee meeting?
I'd like to continue to the next meeting.
Member Wong?
I would too, but I'm also a little biased because I'm not prepared today, and also I won't be at August's meeting. So
no.
I'm not a good person to ask.
Oh my goodness.
Perhaps, Member Wong, you can put it in writing.
Actually, I love that idea.
Fair enough. Yeah.
Then we can introduce it. And if you have any arguments, for or against something, put those into it.
Yeah, I think Chair LaHood, if you provide, the sections you'd like to cover, then I can definitely provide my thoughts.
Absolutely. And actually, I think today was helpful, and I will go back and listen to the audio to see about how much ground we were able to cover, and then perhaps pace it out a little better rather than saying, and we're going to do all of Article 2, which may have been overly ambitious. Because, I do want to make sure that there's opportunity for discussion. And again, just because we've gone, we've had the first pass at these sections, we need to, I know there's going to be a lot of feedback, and I welcome anyone who has other written comments, members and members of the committee and members of the public. And we want to do our best to sort of incorporate these and pull them together before we pass our recommendations onto the full task force.
Sounds like fun.
Okay, so on that note, I would like to continue this item, further discussion on this item to our next Compliance and Amendments Committee meeting. That's my motion. And since it's just do we need a second, or we just need to? Okay.
We need a second. I'm just pausing for Member Wong. Give me the...
Okay, I will second.
Okay.
Anyone have public comment on that?
I will open it up for public comment. We have no one left in the room here. Mr. Young or I guess everyone, microphones are open. Is there any public comment on continuing this discussion to our next meeting? Hearing none, please call the vote.
Oh, hello?
Oh, you do have a comment. Okay.
Sorry, David Pilpel. I have
Yes.
no objection to continuing. I was just going to say I don't know what Member Wong's schedule is in August or meeting room availability, but if it's possible to move the meeting date so that all three of you are present, that would be best. If there's no way for her to participate in person, then whatever you got to do. But yes, I support the motion. Thanks for listening.
Any other public comment? Okay. Ms. Anderson? No. I don't think she was. Okay.
The only thing I would say, I've been sitting here thinking that somewhere in the agenda, when you agendize this discussion, could you put the manner in which we're going to have the discussion? Like we're going to discuss items here to here. If you have any thoughts on them, make sure that you've read those parts of the Sunshine Ordinance. So when we come in, we can have more robust discussion.
Yes, I think I've heard that both from members of the public and members of the committee. So I will make sure that happens for the next meeting.
Fantastic. Thank you.
So Ms. Leger, please call the vote.
Chair LaHood?
Aye.
Chair LaHood, aye. Member Wong?
Aye.
Member Wong, aye. Member Wolf?
Aye.
Member Wolf, aye. Moved by Chair LaHood, second by Member Wong to continue further discussion on this item to the August Compliance and Amendments Committee meeting.
Okay, thank you. Next item, please.
Item number 11, announcements, comments, questions, and future agenda items by members of the Compliance and Amendments Committee.
Members, do you have any announcements, comments, questions, or future agenda items?
I don't.
Well, maybe you want to announce what dates are you actually going to be away in August that you're not going to be at the CEC meeting?
No. I don't.
Yes, I agree.
Yeah. Right, because there's not really an opportunity for us to move this meeting. So,
no, I know. I was going to say at that point, she could say the date that she would be unavailable.
I'd prefer not to make it part of public record.
Yeah.
All right.
Thank you. Member Wolf, any announcements, comments, questions, or future agenda items? Okay. I don't have any either. So I think it's time for to call the next item.
Item number 12, adjournment.
Okay. Thank you, everyone. This has not been our latest meeting, but it was pretty long. I appreciate all of your help and participation in this discussion and look forward to meeting with you next time. Have a great evening.
Have a good one.
Bye.
Bye.
Chair LaHood, we started